Sorry.
Any mention?
My lord, item number 30, my lord. I've taken concern of Mrs. Yangi. Can it be taken up next week, my lord?
Yes,
For us, right?
Not your lordship, I'm appearing under the instruction of Mrs. Yangi.
Okay, after next week. Next week, my lord.
1 week, yes.
And item number 32 and 45, my lord, after 2 weeks, my lord.
45 is under.
32 and 45, my lord. It's all regulation. Yes.
You have no objection? No objection.
After 2 weeks, my lord. And 45, my lord. Item number
45, I
45.
have no objection.
Highly obvious.
Yes.
Your Lordship, I beg to mention item 33 and 34.
Number?
33 and 34, Your Lordship.
Yes.
Your Lordship.
This matters.
Yes, Your Lordship. Mr. Sen has some personal difficulty today, Your Lordship. I'm praying for 1 week's time.
Yes, Mr. Nongpur.
Come after 1 week, Lordship.
Is it a long matter?
It's a long matter, Lordship.
Long matter?
Lordship.
Otherwise, you take a fixed date, no? Then you won't take adjournments, yes.
After 1
2
week,
weeks,
Lordship.
yes.
Obliged, Your Lordship.
Highly appreciate.
Please, Lordship, I beg to mention item 46.
Number?
46.
And the petitioner.
For respondent number 8, Lordship.
You have no objection? No urgency? After 2 weeks, yes.
Obliged.
Supplementary list item number 1.
Please, your lordship.
You have heard the tentative view of the court. We're not inclined to club it together.
My lord, this is the same Akang matter, my lord,
We
dispute.
will give you one concession. It'll be fixed on the same dates, but it'll be taken separately.
Because this, why I want
See,
to...
Mr. Moomin,
Yes, my lord.
it has come before this court. Why was this never raised before? The same.
No, the reason why, my lord,
Why now, if one
I want to
dispute
satisfy
is
this
between
honorable court, why, my
your
lord?
own clan, right? One is Nokma dispute within your Nengmiza clan, right?
Yes.
Then the others with the Mangsang, which your clan is having Mangsang with regard to the Aking. Correct?
No,
They're two different things.
No, my lord.
Yes?
This is an Ajikse Akang, my lord.
Right.
This,
Joint
yes,
Nokma,
joint Nokma, yes,
okay,
two
fine.
Nokmas, yes, my lord.
Then,
my lord, the dispute, they have filed a case against Ningmija clan, my lord,
Right.
the respondent.
right.
Thereafter, my lord, once the matter was disposed of in my favor and it was remanded back, my lord, in the year 2016, they again filed another case against Mangsang clan, my lord.
Okay.
It was them. So, my lord, when the matter was pending, so application could not have been filed, my lord, by both the Nukmas. So, we have impleaded in that case as a party, my lord. And the court allowed it, my lord, and it was, we were impleaded as respond number 6 and 7, my lord. Thereafter, the matter proceeded, and again the matter was remanded back, my lord. So, only after that, my lord, we filed an application for clubbing of the matters, my lord.
No, now what about your other dispute is with regard within your clan only, with regard to Nokmaship, correct?
No, we are not having any dispute, my lord.
With as to Nokma, you have dispute. Then why are two appeals listed? One with regard to dispute that between your own
It is between them, my lord.
Okay, forget Mangsang clan. Mangsang clan has a Nokma dispute, or is it Nengmiza clan?
See, Mangsang clan and Ningmija clan are before this honorable court, my lord.
Right.
Yes.
Right.
Whereas they are claiming to be Nukma of Ningmija clan, my lord. And in fact, in their own admission, my lord, and it has been recorded, they are claiming that entire Dilmagre Akung to be an Ajuma Akung, my lord. If that be the case, my lord, then he cannot be a single Nukma. There has to be another 5-6 Nukmas, my lord. But they have not impleaded as a party.
Between your clan now,
Yes.
there's no dispute for Nokmaship. Is there dispute or not?
No, there is no dispute.
Yes, correct.
No, there is no dispute.
See,
the
between
court
the
speaks,
Minza clan, there's no dispute.
Ningmija clan, they have filed a case against me.
No. Forget about Mangsang for a time being.
No,
Is there a dispute within your own clan for Nokmaship?
No,
Yes or no?
they are
You
claiming
answer
to be.
yes or no?
Yes,
Is there a
ma'am.
dispute or not?
Yes, my lord.
Within your own clan
Yes, my
for
lord.
Nokmaship. Then
That is they are the one they're claiming to be from Ningminja clan, my lord. And they have filed a case against us.
Right, but that's a separate dispute from like the two clan dispute for the Akheng between Mangsang and Ningminja.
No, he's claiming to be the single Nukma of the entire Dilmagri Akheng, my lord. He's not claiming to be only Nukma of Ningminja clan. He's trying to come before this honorable court claiming to be the single Nukma of Dilmagri Akheng. Whereas we are saying that we are Ajaxia Akheng, my lord. There are two John Nukmas, my lord.
Come to the impugn order is very well reasoned.
63. my lord.
This is a wrong reason, my lord. Why I'll say that? I'll try to satisfy this court, lordship.
You read para 6.
Yes.
Yes. Read para 6.
Since the nature of these cases are completely distinct from each other, moreover, the issue in the first instance case is an Nukmaship dispute within Ningminja clan, and the second instant case issue is an Akheng dispute between two different clans. In fact, these two cases have been going on separately for years. Yes, and both cases went up to the Honorable High Court. They actually, when the matter was being pursued by them as a Nukma of a Ningminja clan, my lord, another case was pending between Mangsang clan only, my lord, between two sisters. They have not implemented as a party then.
We're not inclined.
And moreover, the reasoning, my lord.
It's been same day.
Same day it may be taken up, my lord. There is no
Yeah, but
problem.
no clubbing.
Yeah, but clubbing, my lord,
That will confuse everything, Mr.
that will puzzle
No,
everyone.
if it's not clubbed together, why there is a difficulty, my lord? Because we are saying that it's an Ajaxe Akheng, my lord. There are two Nukmas.
Right now, whatever is decided in the first that GGC appeal will have a bearing in the other one. But they can be clubbed together. They can be.
They are trying to segregate the two matters, my lord, saying it to be distinct in nature, my lord. But the Nukmaship dispute,
Why was all along this matter taken separately before this court?
I'll tell you why, my lord.
If it's the first time it's come to movement, we can understand. Yes, this has been going on for how many years now?
No, that is what I'm.
2012, you've been coming up down, right?
No, he was not in dispute that it was a Ajaxia Akheng, my lord. He said that he was a Nukma of Ningminja clan. So meanwhile, there was a dispute between the two sisters in the Mangsang clan, my lord. Thereafter, when the matter went in favor of the petitioner, who is before this honorable court, he came with an application saying that this is a matter of Ningminja clan only, and I am the sole Nukma of the entire Akheng. Then the matter came up to Honorable High Court, my lord. Then when the matter was still pending, we have filed an impleadment. Court allowed it, my lord. And the matter was remanded back. During that point of time also, I did make a submission before the court saying that the matter should be clubbed together and should be recorded. The court said that file an application before the competent authority, my lord. So we did that, my lord.
So anyway, one thing, you filed the objection, Mr. Sangma. We'll hear it for admission hearing.
Lordship.
Yes. Let the objection be on record before we dispose. I was inclined to dispose it today. Has heard Mr. A.G. Movement issue notice. Mr. S.D. is present on behalf of respondents number 1 to 4 and Mr. P.T. Sangma by Cavator for respondent 5 and 6 assets. Rules complete. Stop. On the prayer of the Mr. P.T. Sangma, please want to file a small objection to the prayer made. Affidavit or objection? We'll hear it. List for admission hearing after 2 weeks.
Daily list item number 1.
May I please, Your Lordship? Your Lordship, previously the counsel for respondent number 6 had withdrew herself, Your Lordship, and registry had taken steps upon the respondent number 6. However, there is no report as on date, Your Lordship.
You know what up? The agreement is in the final stage, and this is what's happening.
Nothing has come to the.
Who is respondent number 6?
Yeah, the village.
No, village means represented by whom? We know the village.
Represented by the
You don't know
Secretary. Secretary.
His name.
They have not named, Lordship. Not by name.
You get the
it's
name?
by designation.
Can you allow us to take fresh steps?
Not first step. You get the name of this petitioner, of this Sokumpar name, right?
Second for name also. It seems there's a new office also, Your Lordship.
That is why
Lordship.
Mr. Pasanti submits that though notice has been issued, respondent number 6, they yet to make next appearance. He prays that he will be allowed to obtain the details and the name of the petitioner of respondent number 6 for further steps. Yes. You get the name and we'll issue notice from the court by person on him.
Item number 2.
Please, Your Lordship. Lordship, I'm praying for accommodation in this matter, Your
Why?
Lordship. The conducting counsel due to personal difficulties is not here, Your Lordship.
Who's the conducting counsel?
It's not. I'm for respondent number 6, Your Lordship.
Darbar.
Yes, Darbar.
You are there. You are very competent.
Your Lordship, I'm not well versed with this matter.
Yes.
I'm not well versed with this matter, Your Lordship.
You're not well versed with the matter.
No, Your Lordship, I'm not.
Next week, subject to Lordship convenience.
It's for admission hearing, correct?
Admission is
See, admission hearing and all, court not inclined to adjourn it
I'm praying for short date, Your Lordship.
just for the sake of adjournment. Yes. Yes, as MS Bisun on behalf of respondent number 6, please that the matter be adjourned for today in view of the unavailability of the senior arguing counsel. Just after 1 week. 1 week.
I'll approach.
Item number 3.
Please, Your Lordship. Lordship, if this matter can be taken up after 2 weeks, the conducting counsel, Mr. Sebastius Malot, is having some personal difficulty, Malot. We have already filed a rejoinder as well.
What is the matter?
This is in regard
Encashment of bank guarantee, my lord.
performance guarantee, Malot.
What is on issue maintainability first will be taken
Yes,
up?
ma'am. Yes, ma'am.
After?
2 weeks, Malot.
Yes, Mr. AG Movement and counsel petitioners raise that matter be taken up for 2 weeks due to the unavailability of the arguing counsel on behalf of the petitioner. Accordingly, yes, after 2 weeks, yes.
Hello, please, Malot.
Item number 4.
Please, Your Lordship. Lordship, I'm appearing on behalf of the petitioners. Lordship, may I pray for taking up the matter after 3 weeks, Lordship? There are some talks going on between the parties to resolve the issue, Lordship.
3 weeks?
I have no instruction, my lord, but the issue of
You are Mr. Pritam Barua. What is your name?
Pritam Barua.
Mr. P. Barua, on behalf of the petitioners, please that the matter be taken up after 3 weeks as they are out of court proceedings going
after
on. That's his submission.
His submission, my lord.
Yes, just after 3 weeks.
Which has been denied, my lord, because I am appearing that there is no instruction.
Who's to say? Mr.
Because
General?
I have no instruction, my lord, whether
Courts depend assistance and submissions of the councils only.
Item number 5.
Yes.
5 to 7, my lord, are connected,
Yes.
and 11 to 13 and 24, my lord.
24, man.
This is 5 to 7.
5 to 7, 11 to 13 and 24, my lord.
Yes.
The main issue involved in this case is, my lord, the scope and the power of the collector
To recalibrate or
to
compute.
yes. My lord. Now, to satisfy my lord, I may take some annexures. Section 11 annexures, my lord, we come to page number 45, annexure 1 is the section 11 preliminary
One
notification.
second. Ibu ni kan buat deh, ya belum cak. Yes, sorry.
My lord, page 45.
Page 25.
45, my lord, 45. This notification was issued on 7 October 2021. My lord, whereas it appears to the government of Meghalaya that a total area of such square meters of land is required from 11 villages, from left hand side and right hand side. for the purpose, namely for construction of western bypass as per the boundaries described in the schedule attached therein. Now, this is the notification in section 11. Now, thereafter, page number 64 is the notice notifying the substance of that.
1 second.
Prelim
It's
notification.
7 October 21, na?
Madam.
Section 11 notice.
Madam.
Yes.
And notice 15, page number 45. And the
Yes, now
second,
next is
yes, and the another public notice is page number 46, dated 15 November 2021, notifying the substance of that prelim notification.
yes.
Madam.
It's under section 11 only.
Yes, yes.
Yes.
And my lord, the next page, page 47, is another notice issuing to the individual landowners, notifying the date for, my lord, objections or claim. My lord, fixing with different subjects cited above, I am to inform you that hearing on the claims objection of the above land acquisition will be held on 4th, 5th, and 7th March 2022. Now, thereafter, notice was not given to the individual landowners, but perhaps given to the headman. Therefore, the next page, my lord, the next page 48. These are the minutes of that hearing.
Page 48.
48.
Yes.
My lord, may I take the second paragraph? The land acquisition proceeding will be carried out in accordance with the census 2013, in which, beside the market value of the land, the landowner is entitled to the benefits of multiplying factor, solution and interest, and assessment of assets will be conducted by the concerned line departments, and the same will be calculated in the award of compensation. Hence, this meeting was convened so as to make clear if there is any objection or complaints which are needed to be addressed, and the landowners are at liberty to address their issues so as to enable this office to take necessary action prior to payment of the compensation. The heads of villages present in the meeting inform that there is no objection against the project. However, there are some issues like correction of names, location, inclusion of names, remeasurement, etc., which are needed to be addressed, for which the office has given assurance to the settled matter. But during the course of hearing, some of the minor issues like correction of name and address has been resolved instantly with due certification by the concerned headman, secretary of villages, and other issues pertaining to remeasurement or resurvey of the land and verification of landowners were entrusted to the NHITCL to take necessary action and to submit a report to the office of the collector. So this shows that the landowners are not there, village headmen and secretaries were there. My lord. Now, thereafter, my lord, the state has issued a section 19 declaration, page 49, 9 November 2022.
Yes.
Well, and the next page number 50 is this public notice notifying the substance of that section 19 declaration.
Page 52.
Page 60, madam. Page 50, madam. 50. Annexure 6 is a type copy of the public notice notifying the substance of that declaration.
Yes.
Well,
that is 10 November.
My lord.
9 November was section 19.1?
Yes.
And 10 November 19.4?
Yes.
Okay. Yes, notice.
And thereafter, my lord, annexure 7, the next page, section 21 and 22 notices were issued.
That is date?
My lord. That is date 15 December. 15 December.
Yes.
Thereafter, accordingly, my lord, they have fixed 21 December for hearing under section 21-22.
Yes.
And the minutes of the same, the then sheet is available, page number 54.
Okay.
So, along with the present petitioners, many other also appear and place their
you appeared here also?
Well, some of they also appear. And place that my land is arable land, is a fertile land. Yeah. My structure, houses are there, forests are there, agricultures are there. Give me the suitable compensations. My lord, thereafter, page number 72, the PTO of the Soyong block has given the land valuation to the collector so as to enable the collector to make a proper assessment of the market value. That is page number 72, letter dated 31st March 2023. It says, my lord, land valuation certificates. My lord. Different categories are given. My lord. National highway, main road, motorable road, non-motorable.
It's annexed to the letter.
Yes.
This 73.
Right.
It's annexed to the letter sent by the PTO.
Yes. And 3 types of categories are mentioned. Four types of land valuation has been mentioned. Page number 73. National highway, as per the assessment of the PTO, 5,000 per square meter. So when we see, my lord, the 3 feet are there in 1 meter.
Where you get 500,
my lord,
where you get 500 rupees per square meter?
My lord, page 73.
Okay, yes. But how 5,000 means?
Yes, 5,000 if, my lord, in 1 meter, 3 feet are there. So it comes to 1,500 per square highway area. The main road, my lord, 1,000 per square feet. And the motorable area, 750 square feet, if we divide it per square feet. And non-motorable area, 500 per square feet. That is the assessment given by the PTO, prevailing in that area. So this was furnished to the collector, pursuant to the information sought by the collector. Now thereafter, my lord, page number 76, Annex 10, this is the award where, my lord, the other side is trying to say, but page number 76, my lord, Annex 10. This is the award. After hearing all the parties in the section, my lord, 15, section 21, 22, receiving the feedback from the PTO, now the collector has passed his order, my lord. Seen letter dated such 25th April 2023, received from the General Manager NHITCL, Milem, with the request to submit a final award under Section 23 of the Act, after approval from the state government, rather than submission of the probable cause. Hearing on the Section 21, 22 already conducted on such as showing in the presence of the landowners.
So you mean as per the recommendations of that BDO, this was accepted by landowners?
Yes.
And by the
yes.
Was the NHIDCL present in the meeting also? They were there.
On the they are passing the award.
No, on the day of that, when was this?
Hearing, my lord.
31st March,
yes.
23. Now, this is sorry. When that hearing was held,
my lord,
page 54.
My lord, mechanics, they were there. Page number 54.
They were there.
Yes, they were there. Representative by NHI is still there.
Attended by.
Attended by my lord.
Yes.
Yes. The engineer, consultant, 3 of them represented in NHIDC.
Okay, fine. Then now this land valuation certificate, were they privy to it also? Were they privy? Was a copy marked to them also regarding this valuation?
Marked to the NHIDC?
Yes.
My lord, that one.
Done by the video.
My lord, copy is not marked to them, my lord. It appears.
Okay. Fine. Then proceed.
Yes.
Now this order dated 4/5/23.
Yes. This is the
order
award.
Based on that BDO's valuation. And the hearing. Award.
Yes. Hearing about the
yes.
parties in the section 21, 22.
You know, his valuation.
Yes. He passed the order. The last paragraph may read my.
Yes, and for drawing of award.
Yes. Prepare the draft award according to the adding the mandatory solution of sunset under section from the prelim notification. So my humble submission, on this particular day, the collector has passed the award.
Yes.
And prepare the award in adding those statutory solution. And thereafter, my lord, the next day itself, the next page, my lord, page number 77, collector has forwarded this to the government for approval. Well, I will come to that point. Earlier, my lord, under section 11 of the All Act, prior approval from the government is required, the draft award, the award. Under the section 11 of the All Act, Land Acquisition 1894, approval from the government is required. Now, because of that, my lord, he has the impression that he has to obtain the approval. Now, under section 23 of the new Act, 2013, approval is no longer required. And yet, my lord, he has forwarded for approval on 5th. My lord, may I just read, my lord? With reference to subject cited above, I am to state that the district collector has passed the order dated such for the award of compensation under Section 23 of the Act for construction of such. I am submitting here with the award calculated as per the Act 2013, duly signed, amounting to rupees such, including establishment and contingency charges for favorable approval of the government. The additional amount of rupees such, the third person under Section 33 has been calculated for 575 days with effect from 7 October, that is date of notification, to 4th May, the date of the award. My lord, can you see? 4th May, the date of the award. Here government said that on 4th May, collector did not pass the award. So here he's on.
4th May, was the award prepared the same day itself?
The same day.
Where's that award?
My lord, I'll come back.
Have you annexed it?
Yes, he has the next day.
4th, 5th only.
Yes, he has the next day.
Okay.
Government approval to the award may be therefore kindly be communicated to the thing. Now, enclose award statement.
Government approval may therefore be kindly communicated early.
Yes.
If the letters dated 5th May, then how can award be dated 4th May?
Madam, the bottom enclose award statement, Lordship, can see.
Okay, okay.
The same.
Carry on, let's not.
Yes. Now,
Go ahead.
he has enclosed the award paper, page number 78.
Okay. Yes.
So he has prepared all the award on 4th, and 5th he has written this letter to government, annexing the award statement. And the award detailed award statement has been given there.
Okay.
The market value, everything. And the market value, my lord, page number 74, 78, 79. The market value also mentioned by the collector.
Yes.
And
Yes.
page number 80, point 11, point 15, my lord, the total amount for compensation to the landowners, such would be 700 crores mentioned. Now, this 19, basis of calculation of the compensation. The rate of compensation for the land was fixed as per the valuation of the land submitted by the property development officer, showing such. So, collector admit that the basis on which he is standing is that
his own in the assessment done by the BDO accepted.
Yeah, he accepted, apart from hearing the of the parties. Now, pursuant thereto, my page number 81, the state government has accorded its approval, 26 May. In returning here with the draft award received by white letter under reference, I mean directed to say that the approved valuation of compensation of the award in respect of the above mentioned project is as per below. Now, serial number 8, the total amount of compensation to landowners of the sole share interest, it comes to this one. Establishment contingency. Now, after all formalities are completed, kindly inform government of the following detail, disbursement of the others. So this is the on 26 May, approval was given.
Yeah.
Now thereafter, page number 84, annexure 13. Accordingly, the collector has sent this letter to the NHIDCL to deposit the amount. My lord, kindly page number 84. My lord, with reference to the subject cited above, I am to enclose here with letter dated such received from the Joint Secretary to Government of Meghalaya Revenue Disaster Management Department, being the approved valuation of the compensation of the award for construction of such with the paved shoulder of Shillong bypass for an amount of rupees such. In this connection, an amount of rupees such already deposited earlier. Therefore, you are requested to deposit the balance amount of rupees such. So earlier they have deposited 3 crores. The balance amount was sought to be deposited. Now, when the matter reached at this stage, the NHIDCL manager has written this letter, page number 85, to the executive director, the detailed report, where it seems that he is pointing out that the award fixed by the collector is in the higher side. My lord, later 15 June, submission of final land acquisition award. Now, point number 2, please refer to DC Iskasir Shillong letter, such, file letter, such, submitted demand note for compensation amounting to rupees and such. Well, details of the project as under below. Well, now for Ripoy district, 11 kilometers are there, my lord. For Ripoy district, and East Khasi's 22 kilometers. Total is 38 kilometers. And the next one, my lord, as per the contract packages, they have divided into 3 packages for the contractors. The first package is for the Ripoy 12 kilometer they mentioned. East Khasi 11 and 13, 28. Now, number 4, my lord, administrative approval of the subject work has been issued by the MOHRD violated dated Sunset 2023 under 3 packages respectively, agreed to total laying out rupees Sunset. Now, this is a very vital point number 4. But package 1, 2, and 3 may come to, my lord, item number 5. The estimate done by the ministry at Delhi, my lord, point number 5. For the time being, we'll escape the, my lord, Ripoy is 200 crores. Now, package number 1 and 2 of East Khasi's, package number 2 is a 255 points and such, and package number 3, 225 packages. Now, for the time, my lord, point number 5 of the page number 86.
86, yes, letter of acceptance.
Yes, my lord.
Issued.
Well,
okay.
Point number 5, madam. Cost of land acquisition and rehabilitation.
Yes, no, 5 reading page 86.
86, I'm in 86,
Point number
madam.
5, okay.
Point number 5.
Letter of acceptance for all 3 packages has been issued.
My lord, before that, Lordship, mechanicity internal, point 5 in point number 4.
In the column.
In the column, my lord.
In the column.
In the column, my lord. 1, 2, 3, 4, my lord. Mentioned till 13 they have mentioned.
Page 86.
Page 86, point number 4, and in within point number 4,
yes,
they have provided the table.
Provided.
But
package 1, package 2, package 3.
Yes, my lord. Now serial number 5.
5 is cost of LA.
My lord, exactly, lord. Yes. Cost of land acquisition, rehabilitation, resettlement. The estimate given by the ministry is, my lord, for Ripoy 200. For East Khasi.
For Ripoy 200.
For Ripoy on the top, my lord. Package number 1 is Ripoy. And I pointed out on the top.
Yes. Package 1 Ripoy, package number 2 East Khasi Hills.
Yeah. Number 3 also East Khasi
Hills. East Khasi Hills and Ripoy and package number 2. Okay.
Yes, my lord.
Right.
My lord.
Okay.
So when we combine together, my lord, this rupees 225 and 226 for the land acquisition, for the land compensation, it comes to, my lord, 400 crores 81 lakh something. Now there is an excess amount if we compare with the collector assessment. My lord, 200 crores 92 lakh somethings are in excess over and above the estimate given by the MORD ministry. So he is trying to, engineer is trying to point out this differences, my lord. Now I would go further. Now point number 6.
So what they're trying to say is that for this 38.256 kilometers,
yes,
which is divided into 3 packages, is the amount that has been approved by the Ministry of Road Transport.
Yes.
That means for the first package, that is Ripoy district, that is 200 crores.
Well.
Then for East Khasi Ripoy, it's 255 crores.
Yes.
And for
East Khasi
it's 226 crores.
Well.
So you're saying that taking 2 packages, 1 and 2 together, that is, it comes to only to 400. It comes to 455.
Yes, 481
which is much lesser than the 717, which has been assessed by the.
My lord.
Okay.
Lesser than the assessment given by the collector.
Yes.
So he's trying to say that the amount fixed by the collector is higher. So it requires for revision. He's trying to point out. Now, page number 87, point number 6, my lord. The final award as submitted by the collector. So he has mentioned this office has scrutinized the final award as per the 2023, considering 12% interest under the sales and sunset, calculated only from the market value of the land as standing component and the administrative charges and sunset. 2.5 was calculated as per the stipulated guidelines of the MORT and as per the section sunset. Number 9, additional compensation under section 33 of the Act. 12% as per annum as taken on 575 days from the date of publication of notification under such to 0405/2023 date of declaration of the award. My lord, this is very vital. 0405 is very important. My lord. Now, value of the things attached to the sunset, my lord, he has made point number 10. And page number 88, that was mentioned, for crops, others, it came to 13 crore, 13 point something. Now, the point number 1 of that page number 88 at the bottom, the establishment contingency charges has been considered by DC, East Khasi and Shillong, total amount of sunset. The detailed breakup of the approved award is as per the sunset. So he has reproduced the collector's award, collector award. Now, may I come straight to point number 15 of the page number 89. It is pertinent to mention that the sanction cost towards land acquisition and rehabilitation as approved by the MORT are 200 for package number 1, 255 crore for package number 2, and 266 for package number 3, respectively, which is on the lesser side, as the instant final award land compensation is rupees such, covering part of the such. My lord, this, my lord, hence revised cost estimates or on account of increase in cost of land acquisition as per final award received from DC would be required. Accordingly, revised cost estimate proposal would be submitted for all 3 packages once the award towards land acquisition is also from the DC Ripoy district. At this time, my lord, when he wrote this, collector Ripoy district yet to determine. This office has scrutinized the final award for the subject project thoroughly and generally found in order. However, the same may be pleased to reject at your end as well, and if any discrepancies are observed, the same may kindly be brought to the notice of this office. In view of the above, the remaining amount of rupees such, final award amount such, is recommended to RO Shillong for approval of the competent authority for transferring the land acquisition compensation as per the existing provision of the.
So they approve his DC's rate also.
Yes. So what the manager has pointed out, the variation between the cost assessed by the collector and the central government, and he sought for approval for sanctioning also.
Yes.
Now, pursuant to this, my lord, the page number 91, impugned, my lord, impugned minutes, annexure 15. What they have done, my lord, the over and above the assessment, the award passed by the collector. Now, the minutes of the meeting chaired by the Deputy CM on 7 November 2023 to review the land acquisition. Now, the Commissioner and Secretary Government of Meghalaya informed that the review meeting on the 30th October at Guwahati, the Honorable Minister observed that the final award of the land compensation for Shillong Western Bypass is on the higher side and not proportionate with civil costs, and directed that the state government revise the cost to downwards within a month's time, or the project be dropped. Well, the Chief Secretary to the Government of Meghalaya directed the Secretary to the Government of Meghalaya Revenue Department and Deputy Commissioner of East Khasi and Ripoy to review the cost of land acquisition in line with the cost adopted during the registration. The Chairman instructed the Deputy Commissioner to submit the revised cost of the land acquisition to near about the amount as per Section 11. Now, Collector has done under Section 11, and asked him to submit on or before 30th October, 28th October. Now, here I have challenged is over and above, madam, the assessment given by the central government is the preliminary budget, madam. The assessment given by the requisition authorities is not binding to the collector. Is not binding to the collector. Now, the award determination is purely vested with the collector. Now, what they are trying to do is that, my lord, I made a certain estimate in Delhi. Now, on the ground, you are coming up with a certain assessment award. It is higher than mine. So you come down, otherwise I'll drop the project. So therefore, to stop the dropping of the project, they say that you go for reviewing your award. This is highly illegal. I'll cite the authorities later, with Lordship permission. Thereafter, my lord, the page number, my lord, 94, Annexure 6, another impugned order. Pursuant to this, the state government has directed the DC to review. My lord, later 14 December, go to my lord, meeting 4 December, 7 November, my lord. With reference to the meeting held on 4 December and 7 November on the subject cited, it is observed that directions issued instructing the Deputy Commissioners to submit the revised course of land acquisition near about the amount as per Section 11. On or before 28 November is yet to be received in this office. The urgency and importance of the matter was clearly made known to the deputy commissioners during the meeting and for which necessary action was awaited. However, it appears that the same has not been taken seriously enough, inviting possible ramifications which are not acceptable. You are therefore requested to submit a revised estimate immediately to this office on or before 15th November, and such. This is the approval of this. So direction has come.
1 day time.
My lord. This amount absolutely this is without any authority. My lord. They are dictating the collector. Now, secondly, my lord, after 3 days, page number 95, the NHIT had also written this letter to the collector, the two collectors.
3 days, this is 27 December.
27 December. Another one is 14 December. State has written on 14 December.
Yes.
And NHICL has written on 27 December. So directing both the collectors that you review your award.
Yes.
Now, accordingly, my lord, they have reviewed. The collector has reviewed, though they don't disclose the award paper we saw on the RTI, they're not disclosing. After that, my lord, page number 97 onward, they have issued a award notice to individual landowners, my lord.
Yeah.
Page number 97, 26, my lord. They have mentioned the award amount to appear before them on 4th May. Please note that you will have.
This first person got 40 crores.
My lord, 41 crore, 40 crores.
Who's this person? He's
one of the
headman.
petitioner. One of the petitioner, yes. He's the first three petitioner.
He's a headman.
But he's not a headman. He's a landowner. He's a landowner.
He's a landowner.
He's a landowner. Please. Yes, yes.
So one person got 90 crores.
Yeah. Those are there, madam. Now, please note that by page number 97, that you will have to produce this notice along with 2 copies of photo-size photograph, ID proof, EPIC, land documents, revenue stamp, and photos and such.
So no, there's one gap now.
Yes.
The thing is that maybe they can be able to fill it. After this review was done, then the money was placed with the collector. Where's the process?
Now, under the RTI, I'll come to that one.
The process?
My lord,
The thing is that now you ended it at the request for revision of the rates, correct?
Right.
Yes, and after what transpired within that time and how was that exercise carried out, whereby they reviewed, now you come to notice where they've been asked.
Yes.
Under section 37, correct?
Yes.
So 37.
Right.
Yes,
to receive the award.
To receive the amount.
My lord. And Lordship has pointed out when they review and
now when did it happen? Now this is 26 Feb 2024.
My lord.
So everything happened between in January and within a window of around 8 weeks or less than that.
Yes. Within that period.
Where are those materials?
My lord, I would come.
On which way the decision was taken?
My lord. Now that my lord, the amount of a review, it appears that my lord may come to page number 347.
I mean, where you say that it is without jurisdiction and totally illegal and over and above
those pleadings are there.
Over and above the provisions of the Act.
Yes. Now, my lord, under the RTI reply, page
57.
number 347. 347.
Now we're getting somewhere. Yes. Where is that?
My lord, the last paragraph, the last point, my lord, can be kindly see.
Yes.
The project construction of the Shillong bypass does not fall within the budget of the state government, and there is no budget allocation from the state government since the same was directly funded by the Ministry of Road Transport and Highways through the requiring department.
Now, what are your queries in this one?
My lord.
What are your queries as RTI? Now, were you aware that the rate had been reduced?
My lord, now
because see, this is dated 29 July.
Yes.
When did you file an RTI application? Now, were you aware that there was a move for reduction of the rate? You were not aware?
After they received the award notices to submit all the documents, they came to know that, my lord, the amount mentioned in the award notices are lesser than the award passed by the collector.
This is the 1 second. Let's go back to.
Go back to my lord, page
So
number
now
97.
the thing is that you got your 26 February, right?
Yes, ma'am.
Your petitioner number 1.
Yes.
Now he got it in 26 February. So
But he did not
When
get.
did you file RTI?
My lord, he did not get the money.
He took an objection.
My lord, I'll just clarify this point.
No, just to clarify, just so that they'll get the
Yes.
so that I will get the sequence right.
Right.
Now this revision was called for. Notice was given at 37. Asked you to collect the money.
Yes.
Did you accepted the money?
My lord.
Check.
My lord.
Number one.
Yes.
Yes.
What will do,
did
my
you
lord?
file or did you object to the amount given in the notice?
My lord, I
You
point out.
objected.
Yes.
That
My
is
lord.
there on record.
Yeah. My lord, I'll
No,
just.
please answer. So we can go
On the
ahead.
day, my lord.
We will not take too much time also.
Right.
Now, did you object after this notice was given? You objected.
Now, when we are asked to submit all the documents on 4th May, my
Yes.
lord, we say that the amount mentioned in the award notices, compared with the award determined by the collector, is
So
lesser.
you took the amount under protest.
So therefore, we raised the protest.
No, did you take? So you accepted the amount. You lodged your protest.
Now, on that day, my lord, they did not receive the money. What they have done on 4th May, fixed by the collector.
Just be clear. Is any letter of you expressing your protest on record in the material before this court?
But in writing, it is not there. In writing, it is not there. But orally, when they submit, they protested, and the officer of the
You have a call
collector.
to take evidence here. On the
Well,
oath.
well, I'll come to that point, my lord. Now, after they submit their documents on 4th May, amount was not released, given to them. The amount was transferred to their account subsequently in the month of May, June. So they don't know exactly on 4th May how much amount they are going to receive. No matter it is mentioned in the award notices. My lord, kindly say, relook to the page number 97.
No, only that. You see, the thing is that these acts are very predictable in the process or the course that they take in the proceedings. Correct.
Yes.
So that is why just courts want to know whether these, these other the what you call requisites that you have to fulfill. Now, whether from the side of the petitioners also, they had made the protest or they accepted the amount, or whether coming back now as an afterthought, in a sense, or whether they challenging, or whether you have other recourse. That's the only thing. Yes. Please continue.
My lord, page number 94.
No, now, when did you file? Where are the queries of the RTI?
My lord.
Let us see. Where is your query? The queries that you've given, because you said that you
My lord,
referred
may
to
come
this. Because
yes.
RTI reply is 29 July 24.
Yes.
Yes.
My lord, may kindly first come to page number 300. My lord, 332.
Okay. Just 1 second.
This is letter written by collector depositing certain amount.
Queries.
No, I'll come to that point, my lord. But
No, please,
let me just point out.
also assist the court. Please come to queries first.
My lord, we kindly come to page number 334. 33. 33. This is RTI.
34. I'm not, don't want to be terse, but let's just, so we can get somewhere fast. Yes.
And my lord, may kindly come to 334 page, point G and H.
34. Okay.
Whether the award was granted to any landowners, if yes, kindly provide the details of the award enclosed herewith. Kindly provide the basis on which the awards were computed, enclosing with your reply.
Whether language has taken place and payment methods were effectively implemented, this you filed on 1st July. RTI query. Yeah.
And thereafter, the reply is, my lord, page number.
Issued regarding if yes, kindly issued number notifications. So the issued landowners to be acquired with a public hearing, kindly provide outcome of the hearing.
Those details are sought.
Awards were granted landowners, kindly provide based on the awards computed, whether they allocated a budget. Now, where's the matter with regard to the decrease in the rate?
My lord, that they were not exactly aware how much it was reduced.
You didn't know.
My lord, therefore they sought RTI.
Oh no, on this date, that's 1st July.
Yes.
Now you got your notices. You got your notices on that is on 20
February. 36
yes,
February.
Under 37, correct?
My lord, yes.
37.
And they were asked to submit.
Now you are aware of how much land your land is gone, correct?
Yes.
And you are aware that point of time that it's not as per the rate was assessed by the deputy initially, correct? Now in the RTI you have not asked why it was done. It's not asked.
My lord, subsequent RTI it is asked. I'll come to that. My lord, the reply, first reply to the RTI, my lord may come to page number 335.
No, I've flagged that just now, 347.
Yes.
335.
335, my lord, the reply to the RTI.
This one.
Collector has given reply. 335. Now reply for the purpose of construction of bypass, such, copy of the office and such June enclosure with previous notification, public notice, declaration, public English and such. Sought for your regretted. Other information with regard to award, they say it is regretted. They don't disclose.
And the reply in 347 is to what query? 347? This other one you showed.
The 347, madam.
Yeah, next year.
My lord, I'll come.
The same application there 1st July.
Yes. This is, my lord, when we put up the RTI to collector and the NHITCL.
Okay, these are two replies.
Yes.
Okay, very good.
And the NHITCL reply is page number 336.
No, this is not important because he has not asked any relevant question.
So he has referred, collector has, the NHITCL PIO has referred with regard to award to the collector, TC. Therefore, second reply was given in page number 347. 347.
347 doesn't answer anything because sorry, the thing is that we are just looking at your queries. Your queries have not touched upon the aspect of why was as to what was the process why the assessment was reduced. There's nowhere in the RTI. So fine. So these are material.
They sought for the award paper. Award paper will demonstrate everything, madam. They did not provide, madam. Instead of providing that one, my lord, may kindly see page number 347. Total amount of land compensation deposit to this office is rupees, my lord, is mentioned at the bottom. It's very important. Page number 347 at the bottom. Total amount of land compensation deposited to this office is 473 such. Now this is even less than the assessment given by the MOD RTC, the ministry. So the collector is saying that in my office for land compensation, they have given requisition authority has deposited this amount. Therefore, accordingly, I have disbursed it.
Okay.
And this amount is in fact even lesser, 15 lakhs lesser than the assessment given by the ministry at Delhi.
Yes.
Well, then thereafter, my lord, may come how they deposited, they transfer the amount. My lord may take pain again to see 332 of the writ petition. Well, my lord, after submission of the documents, on the day they were called for, on 4th May, they didn't receive any checks. Well, they went and submitted their identity proof and the documents only. And when they reached that, it seems to be the amount mentioned in the award notices are lesser than the award determined by the collector. They say there is a review process. It will be determined the compensation will be paid accordingly. Now, thereafter, my lord, collector has written this letter to the bank. Transferring, sometimes they transfer, and accordingly, the bank used to transfer the account to the individual landowners. So, on the day they appear, none of them receive any money.
Now, no one will receive any money.
Exactly.
Yes.
And subsequently, they transfer. So, what amount exactly they are going to transfer, we don't know. Therefore, they say.
But it's indicated in the award.
It is mentioned. It is mentioned. Therefore, on that day, they say that it appears that the amount mentioned in the award.
You can't go on, just conjectures and surmises that that they didn't know, that they wouldn't know. But the award was given a physical copy is given to you.
Right.
Amount was indicated.
Right.
That amount was transferred electronically to your account.
Right.
Correct? Okay.
But ISCA seals, they mentioned the award in the award amount. Whereas the Nongpo report, even the award amount is not mentioned.
Okay.
Right. Now thereafter, my lord, when we come to page number, my lord, 348. The detailed RTI also put up again, since they say that, but they're not furnishing the detailed documents. So detailed information was sought here. Page number, my lord, 348.
23, yes.
My lord. Now, may I take point number 10, 11, 12, 13? The specific one, lordship has.
Yes.
Now, the copies of the award showing the details of the names of the applicant, landowners, nature of their land, areas, market value, apportionment of the compensation, their signature showing the approved award amount of such and such. Copies of the final award showing the details of the names of the... Now, it was
revised to 479.
Yes. Yes, madam.
Right.
Copy of the order letter communicated to early showing the authority who passed the revised, review, reduce, award amount. Madam. And thereafter, copy of the order record showing the remaining percentage or part compensation due to be paid to the applicant, landowners, if any. Copy of the balance amount. Well, and 17 also, my copy of the orders records, if any, showing the authority or collector who made the revision or review reduce the award from the approved final amount to rupees and such. And here the RTI reply say that it is done by the government. But I'll come to that reply. That reply, my lord. My lord, may kindly come to page number 374. Is the RTI reply to this application by the collector office. My lord, I may take to point number 9, 10, 11 onwards, my lord. Now it says, information sought for this regretted. We asked for the award copy. Award copy has nothing to do with the privacy, my lord. It's my award paper.
But this is a different application, 28 October. The other RTI also 13.9, as per what I've seen, just 13.9.24.
Another application also there. It is there.
Just reply to which RTI application? That is lecture 23.
Yes.
You sought the detailed RTI sought. That is dated 13.9.24. Yes. Now this 5th November 24, it is reply to which one?
My lord, they have mentioned. Where's the page? 23rd, my lord, may kindly come to.
No, there was
page
13.
My lord, page number
23 you see.
Yes.
That is 13.9.24.
But another one, RTI, my lord. My lord, can you see page number? It's 23. My lord, this RTI was put up on 23. Page number 350. RTI did.
This is the second one. This is 13.9. 23.9?
23.9.
Okay, sorry. 23.9. But this is reply to 28 October.
Now, yes, they are replying.
No, this reference your letter 28 October. Where's 28 October query? Where they've said that we can't finish. Where's that 28 October query? Your RTI application? You should correlate. No, if where's the answer to 23.9 then?
23. Well, not this one. I think this is the only RTI they refer. They mention as this date, but 28 October. But the RTI they put up. RTI they put up is
question 11 from the RTI 23.9. Question 11 says
11 information for recruitment. 11 is
11 says
11 is
final award should detail the named applicant landowners, nature of the lands, areas, so and so and so and so, awarding to so and so.
Yes.
Now they say 11.
They say that information sought for is regretted.
Are you sure this is the answer to 11?
It is. But this is the one they are replying. Well, and number 2 of copy of the minutes meetings and such.
Copy of the open order letter on communication authority past revised review.
Yes.
12 is a copy of the minutes.
Yes, they have given. The one minority minutes adopted by the committee.
And then
in the presence of the
call the order of any part payment company 13.
Yes. They say not available.
Okay.
And 14 also, they say not available.
Answers this, according to you, this answers here, this 23.9.
My lord. So many vital informations we sought for, they are not disclosing. And my lord, we come to page number, the point 17, the last one.
You only want to show that the details are available to you. First.
Yes, yes. Okay. So they are not furnishing the...
Reply says no details.
Well, yes. So once, my lord, my humble profound submission is, once they provide their award paper, we will come to know how much he has reduced it from the original.
You know, by your query number 11, you know that it's reduced to 479. Yeah. You know that earlier on your next document, package 1 and 2,
yes,
is 200 crores and 255 crores. That means 455 crores. So together with other contingencies and other things, will come to 479.
Right.
You know it's been reduced.
Right.
Yes.
Therefore, we sought for in document with evidence.
What is saying for the details?
Yeah, details.
Yes, okay.
Details one.
Then what happened?
And 17, point number 17, they said, who has a review?
Yes.
And they say that this is done by the
legal notice.
Collector, yes. Now thereafter we send for legal notice. Prior to that also, my lord, some of them has filed a representation to release the pending one. That is page number, my lord, 372.
Okay.
Before legal notice, they also they don't respond. And thereafter legal notice come. Thereafter the others are the pictures, my lord. Now before I take the authorities, my lord, I may take the pleadings of the respondent.
Why annexing these pictures?
Well, it is my lord, at the time of filing the petition, we are demonstrating the latest status of the construction of the highways.
Oh.
For that purpose only.
Which section is this one?
Well, the entire villages.
You've written which section is this?
11 villages.
Who are before this court today? No, these pictures relate to which area?
But it is the acquisition area, my lord. Though, my lord, we did not identify the villages, name of the villages. But the stretch, the stretch of construction, they capture and annex this one.
Is it along existing road or is it a new road altogether?
It is a new road altogether.
Okay, very good. Yes. Next,
my lord.
What is your other submission?
My lord, the affidavit filed by the collector, my lord, I received on 29 April 2025.
1 to 6.
My lord, 1 to 6. My lord, it is filed by 1 to 3. It should be 1 to 3. Because the law is very clear. I will cite the authority. Collector do not represent the state in the land acquisition matter.
Yes, that's correct.
My collector office is respondent number 1 to 3 is the collector office. Now he stated that 1 to 6 are filing the affidavit.
Yes.
So according to me, it is defective affidavit in any way, my lord, should be construed as an affidavit filed by the collector only. Now
we'll take it even after filed by collector only.
Yes.
Because there is only this. So then, yes.
Now, if we cite they have taken the plea, my lord, reference, one plea they have taken para 5 that I should have gone to reference authority. Filing a writ petition is wrong, is not appropriate. And at the time of receiving, dispersing the compensation.
That's why this court, as to how you're seeking the invocation for 6. Because when you have statutory remedy.
Yes, well. And second is when dispersing, while dispersing the amount, we are not put up any protest or the objection before the collector.
Whatever, even not protest something, even you have recourse section 64 there, section 77, all those sections that they have a time deposit, then who's payable to and amount. Yes.
Right. These are the substance of the affidavit. And the affidavit filed by the NHITCR, they also say that review is done, the sponsoring body is the ministry, so they have the right to prepare the budget. And when the assessment given by the collector award is higher, it is the duty, paramount duty of the ministry to seek for revising of the award. So there is nothing wrong. So in both the affidavit, they did not dispute the legal position that collector has no power to review the award. Now they did not deny that with the evidence that 045/2023 is not the award. They did not deny the approval. They admitted everything. Now I would not go further. I would cite the judgment that the issue is, my lord, whether collector, once he determine the award, whether he has the right to review or not. Now my humble submission is that if the collector determination is not satisfied to me, inadequate, I would resort to reference authority. But my grievance is different. My grievance is, my lord, if the award given by the collector is 10 rupees, and at the time of releasing, he did not give me 10 rupees, but gave me 5 rupees, 6 rupees. In that method, by reviewing the order, he reduced it.
So you say that the decision taken by the state, by the respondents, is outside the purview of the act.
Yes. Well, exactly.
And it's not and remedy available to you. No efficacious remedy available to you under the act.
My lord.
And so, okay. Yes.
My lord, this is my humble submission.
You have need authority support.
I would cite, my lord, the few judgment authorities, the finality of the award given by the collector.
Yes.
I concede, my lord. I agree that award of the collector is final.
Yes.
And the only so therefore I agree what my friend says.
I would cite few judgments only. And my lord, first judgment would be, my lord, 2006 volume 2 SCC, page number 416.
416.
My lord, relevant para would be 25.
BP Singh.
Para 25, my lord.
Yes.
My lord, the collector is required to hear the persons interested and inquire into the objections, if any, raised by them on the points which is required to determine. It is possible to conceive that he may hear the objections on several dates having regard to the number of objectors and the nature of the dispute that may arise, whereafter he may make up his mind and prepare his award. It is not expected of him that he should prepare his award in presence of the person interested. Since the collector may take some time to make up his mind on the matters he is required to incorporate in his award. Thereafter, he is required to send his award to the government for approval. The approval of the award may take some time. It is not known to the collector as to when the government will approve the award. However, after the award is approved, if there is no alteration in the award, it is required to notify the parties concerned about the award. He may do so by fixing a date on which the parties may be required to appear for pronouncement of the award, or he may inform them by giving them written notice of the award. This is because an award is in the nature of an offer and must be communicated to the persons to whom the offer is made. There is nothing in Section 11 which expressly requires the collector to announce his award in the presence of the person interested, though there is nothing which prevents him from declaring the award on the date fixed by him for the purpose. However, having regard to the provisions of Section such of the Act, he must give immediate notice to such of the person interested as are not present personally or by their representative when award is made. Thus, there can be no doubt that after the award is approved, the same becomes an offer to be made to the person interested, and this can be done by either giving notice to the person interested of the date on which he may orally pronounce the award, or by giving written notice of the award to the persons interested. The question of limitation of filing a reference under Section 18 and 30 of the Act has to be determined by reference to the date on which the award was either pronounced before the parties who were present, or the date of the receipt of notice of the award by those not present. The mere fact that
now, now when the rate of the BDO is accepted by the Deputy Commissioner,
yes,
then the collector, let's send it for approval. No, you have submitted that's not necessary now in this new act.
My lord, my humble submission is on the day he passed that on 4th May.
That order becomes final.
It becomes final.
There is not necessary for approval also.
It is not necessary.
Divorce any approval, it becomes a final award.
My lord, to satisfy my lord that important query. Lordship, may kindly see Section 11 of the All Act first.
Well, other acts was that the collector makes the assessment.
Yes.
He sends for approval.
Yes.
36.
Then the government approves.
Yes.
Then he publishes the award.
Yes.
Section 36,
exactly,
my lord. Similar provision. 36.
Yes.
It goes to the.
No. He's.
My lord, we come to Section
in the new act only.
I said that is not necessary.
Section 11 of the All Act. My lord, we kindly see first. Section 11 of the All Act.
Interesting.
1894.
Yes. Section 11.
My lord.
Yes. Yes.
My lord, Section 11.
Inquiry.
May I take the proviso?
Yes.
First proviso, my lord. That provided that no award shall be made by the collector under this subsection without previous approval of the appropriate government or such of the officer as the appropriate government may authorize in this behalf. So, but provided further that it should be competent for the appropriate government to direct the collector may make such award without such approval in case of cases as the appropriate government may deem fit. So approval is mandatory under the All Act.
Okay, now
when we see the new Act, my lord, yes, may kindly see Section 23. Can you see?
So issue of finality, like you say.
My lord.
Yes.
Section 23 is the all Section 11. My lord.
Inquiry, yes.
My lord.
Yes, read it.
Inquiries, my lord. On the day so fixed or on any date to which the inquiry has adjourned, the collector shall proceed to inquire into the objections, if any, which any person interested has stated pursuant to a notice given under Section 21, to the measurement made under Section 20, or into the value of the land at the date of the publication of the notification, and in the respective interest of the persons claiming the compensation, and Rehabilitation Resettlement shall make an award under his hand. True nature, my lord, these are the things. So approval of the government is not required.
So it says shall make award on his hand. 7. Okay.
But we collector has it because my lord primarily the collector has determined under the parameter section 26 onward, provided the factors, market value, everything
that is fine. Division market land, so on, that is it becomes those other exercises. But only thing, this court going to see whether that the use that approval.
Yes.
Yes.
Now the
whether the same principle will or procedure will apply.
Yes.
In the earlier cases was that collector makes assessment,
yes,
goes to appropriate government, they approve it, then awards published.
Yes, yes.
In this case, it is not necessary.
Not necessary.
But not even then, they sent it to the appropriate government who
yes,
approved it also.
And they approve it.
Okay. But there's no formal award except that order did 4-5.
4-5 along with the award statement.
That's
award
all.
Statement they have an X. Okay. And award statement is the important one.
Yes, yes.
And therefore the 2006 judgment says that once the governments approve it without alteration, it is final.
No, there's no question of approval of the government.
Approval, therefore, in my humble submission,
final from the collector's
yes,
table itself.
Right. Therefore, the award is the award fixed passed by the collector is final. Now, I would, my lord, section 37 of the new act, my lord, the finality of the award.
Section
37, my lord. Awards of collector when to be final.
Yes.
My lord. The award shall be filed in the collector's office and shall accept as hereunder provided be final and conclusive evidence as between the collector and the person interested, whether they have respectively appeared before the collector or not, of the true area, market value of the land, the assets attached thereto, solution so determined, and the apportionment of the compensation the person interested. The collector shall keep open to the public and display a summary of the entire proceedings undertaken in case of acquisition of land, including the amount of compensation. So even he has to disclose to the public, despite of seeking RDI and RDI, they are not disclosing. So my humble submission.
Anyway, let's not go there.
Yes.
Yes.
So my humble submission is that on 4th May, that becomes final. When he passed that order and prepared the award statements, before he referred to the government on 5th May, that award is final. And that is binding to all the parties, yes, including the requisition authorities. If the requisition authorities until he said, no, the financially not viable, my lord, they can request the government to denotify the acquisition and drop the entire proceedings. That is the only option. Provided the land possession was not taken over. That time, my lord, the possession was not yet taken over at that time. They could have done it. But instead of doing that one, they are bargaining. The amount fixed by me in Delhi should be suitable to Shillong in Meghalaya. If not, we will drop the proceeding. So the state was intimidated by the ministry. So they brush aside all the authorities of the collector.
That's your submission, but then you have to have cogent materials to say that,
But therefore, if Lordship may even if my Lord call for the award paper of the award statement on 4th May 2005, it will be revealed, my Lord. If the Lordship call for the subsequent award paper
so
also.
Position to return the money now. Suppose it denotify.
My lord, once they have taken over the position and construction is done, my lord, acquisition cannot be withdrawn. Lordship is very much aware of that. Now, my lord, if I just take a Lordship citation to section 30 of the very act, my lord, section 30. Award, section 30.
Yes.
when the award will take effect, my lord. My lord, you see section 30 of subsection 3. May I just read out, my lord.
Whole act.
New act. New act. New act.
Section 3.
Section 30.
Additional market value.
Section 30, my lord. 30.
In addition to market value.
Sorry, award of solution, my lord.
Yes.
Yes, and subsection 3, addition to market value, my lord. May I read, my lord. In addition to market value of the land provided under section 26, collector shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on from the date of the publication of the notification of the social impact assessment study under subsection. But here, social assessment was exempted, in respect of which land till the date of the award of the collector or the date of the taking possession of the land, whichever is earlier. The date of the award. The date of the award, even the court says that it is 4th May. So that is the final award. Now, I may cite one judgment, my lord, where
no, this has no relevance to our case. This 30 hour of solution.
Because
that's consequential on, if we have a dispute with regard to the quantum, that's all. That, the solution not given or.
They say, my lord, they say that on 4th
That
May.
will come in reference. That is totally a matter of reference, not a matter for a red court to go into 12% from the date of publication to the date from the date. That is not a matter for. That is a totally different remedy. Then if you seek those kind of remedies, then we have alternate remedies. That is different. We are going only on that core issue, that whether they have, where does their power flow from to reduce the awarded amount which you submit is final by the collector. So you have to see this, where do they have the power vested in them
I'll come
to do such a thing which you to bring it under the confines of jurisdiction is arbitrary. The decision making process is wrong. That's it.
My lord. To satisfy my lord query, I have to satisfy lordship that award is final.
Award final. Okay, we take award final now.
Now, lordship kindly see 2004, volume TABCC.
Yes.
Page number.
Old act. This is old act. That means.
2004. Give me come to 30 citation.
Principle of law will be the same, but is it regarding old act and new act?
Yes, I can give you.
Citation in advance, citation, I can take out book.
2004, volume 12, ACC, page number 306,
yes.
relevant para 11.
Yes.
My lord, para 11. Parallel merit. Pursuant to the order dated such passed by this court, the state government filed a translated copy of the award dated such, shown as a true evidence, which has been subsequently corrected such. Even otherwise, the fact that award was made on 25/7/1992 is not disputed. The copy of the award dated such is accompanied by an affidavit dated such, sworn in by such advocate on behalf of the appellant in civil appeal number rising of itself in a person such. The award sunset was clearly passed in proceeding under Section 11 of the Act. At the time of the hearing, learned counsel for the state sunset so produced an English version of the award dated such have been passed pursuant to the agreement such. The subsequent award is shown to have been passed under Section 11(2) of the Act. We are surprised to note as to how the subsequent award dated such was made pursuant to the alleged agreement dated such. We smell a dread. When the award is made by the collector under Section 11 of the Act, the proceeding before him stands terminated as soon as the award is made. The provision of subsection 2 of 11 is attracted only at the stage of the proceeding before the collector, that is to say, if the collector has not passed the award under Section 11 of the Act, and proceeding before him were still subsisting. In the present case, it is clearly appears from the award dated such itself that it was made under Section 11 of the Act. The claimant such also categorically stated that he received the compensation amount pursuant to notice dated such. That statement remained uncontroverted. In our view, therefore, there was no occasion for the learned collector to have recourse to subsection 2 of the 11. There can never be two awards, one under Section 11 of the Act and another under subsection 2 of the Act. So my citation, my lord, is to convince my lord that once the collector passes an award, that is final, there cannot be two awards. Now reviewing the amount.
No, you are standing, I'm trying to understand. You stand that 4523 is a final award after reason. So no, there can be no deviation from that.
Yes,
okay, yes.
my lord. And now I'll come to that very one. My lord, I have copy. Give the other copy for the other parties. My lord, this has a bearing, my lord. Here, collector has determined the award and given a compensation for the structure. Subsequently, he reviewed. That's all, saying that, my lord, I should not give the compensation for the structure. So he reviewed the award and reduced the amount. Yes, reduced the amount.
Just under the old act or new act?
Old act,
Old act, yes.
Under the old act, my lord. The way that was passed. My lord, I would take relevant para 8 to 13.
So your contention is that all statute provides for review.
Yes.
There can be no authority to review.
Yes. And that too in the under Land Acquisition Act, my lord. Discuss. My lord, can you see para
these citations?
Para.
I agree. This
para 8, my lord. 8 to 13.
Yes. Okay, noted. Yes. We understand. Other citation?
Para 8 to 13. Here, by 2010 also. Decision also, it is cited there. The Supreme Court said that unless the statute provides for review.
Under old act, unless statute provides, yes.
So under the Land Acquisition Act, this was award was passed under Section 11. But it is the same. But Section 11 of the old Act is now Section 23 of the new Act. Now here, Jammu and Kashmir High Court also, my lord, similarly they have reviewed the award and tried to recover the amount. And there, my lord,
paragraph?
My lord, I would come to para 7, 8 and 9, 7, 8 and 10.
Which 1990? That is a Jammu Kashmir Act.
Jammu and Kashmir is a division bench order passed on 25th April 2023. Para 7, my lord.
It is a local act, my lord.
Para 7.
We have a local act. What's happened to the Meghalaya Acquisition and Act?
Oh, yeah, my lord.
There's an act also.
Yes.
Yes.
Para 7, my lord. Para 7 and 8.
Yes.
I take straight to para 7, my lord. Having heard learned counsel for the parties and perused the material on record, we are of the view that after the collector makes this award under Section 11 of the Land Acquisition Act and files it in the collector office, the same should be final and conclusive evidence as between the collector and the person interested of the true area of the value of the land and apportionment of compensation among the person interested. That is so evident from breathing of sections and such. The party aggrieved, a person interested who is aggrieved of the award and has not accepted it may, written the application to collector require the matter to be referred to for determination of the court, whether his objection to be made to the measurement of the land, the amount of compensation or the apportionment thereof. This first right to seek reference by the person interested is provided in such and such manner. From a reading of the entire Land Acquisition Act, we could not find any other provision wherein the collector, after passing of the award, is empowered to recall or review the award or issue direction for repayment of compensation or recovery thereof, contrary to what it is provided in the final award. We do not, however, dispute the proposition of law that if the possession of the land acquired has not been taken over, the competent authority may withdraw from and denotify the acquisition. So my humble submission is, my lord, here, review has been done in Jammu and Kashmir.
In the case, they have to refund the money.
But yeah, and they want to recover it. So High Court said that no, you cannot recover it. Recover it. If any third party is claiming, they have to go for before the reference court. Now, the other decision, my lord, 2019.
Now where's the order of recall of the latest award?
My lord.
Where's the order of recall?
There is no order of
review.
No, in our present case, now where's that order was recalled? It says that we had fixed it at 717. Now it's 459 or something.
They are not supplying it. Lordship may summon the record in the Land Acquisition record. It will be revealed. We saw on the RTI.
You mean there's a recall? There's a recall of the award.
Review.
It is on paper.
Reviewing the award. without reviewing, my lord.
You have not disclosed that in your affidavit.
Yes, my lord, I have everything. Only 2 minutes, my lord. My friend is over. So in 5 minutes, my argument will be over. 5 minutes, not more than 5 minutes.
I will
These judgments are also not required, my lord. Okay. On the facts only, I have to show 2 pages, my lord. Only 2 pages, my lord. Nothing more than that.
5 minutes or 2 pages?
2 pages, that's all. The 5 pages, 2 pages. I have to show. I don't know why my friend is arguing so much.
Here is the government suppressing the fact.
He has to have witty arguments. He has to add his present 200 crore argument. He was seeking 200 crore plus.
My lord, government is suppressing.
Now, in case if they don't review, collector do not review it, the balance amount approved by the government or fixed by him should have to be released to the landowners. They're not disclosing that one also. And show me when you review. Date of the review, they're not giving the copy. Where the citizen will go, my lord. The other decision, my lord, I'll cite only 2 judgments. I'll raise my argument, my lord. 1987, volume 2 SCC. 1987, volume 4 SCC, page number 525.
Yeah.
Relevant para would be 12. My lord. Here, my lord, the state has taken a plea that alternative remedy is there. So High Court is not appropriate forum to challenge all this reduction or review. So I'm citing this, my lord.
Why citing this old judgment? There's so many new judgments.
My lord, here only I want to cite the Supreme Court held that if the review is passed by the authority without jurisdiction, though alternative remedy is available under the Act, party can challenge
on the question of court.
Yes. So in my submission, even if, my lord, the action of the collector is bad, I can go to reference court. But with regard to review, since it is without jurisdiction. Yes, para 12. Paragraph 12.
Para 12.
Para 12. And the last decision, may I please, Lordship permission is.
1 second, let us see.
Fine. Para 12, my lord.
Okay, is this a general proposition?
Here also, my lord, the university VC has no power to review. He reviewed the order,
that is other,
and therefore
the other cases also.
that is the case, my lord. Alternative remedy is available still. Matter can be challenged before the court for illegal review. Last judgment, may I please, my lord, 2005, volume 7 SCC, page number 6. 5, volume 7 SCC, page number 627, relevant para 18. There I would not read further, my lord. Here, my lord, the collector para 18. Well, in view of the fact that the action required to be taken by the state government is distinct and different from the action required to be taken by the collector, when the ultimate order is in question, it was for the state to satisfy the court about the validity thereof, and for the said purpose, the counter affidavit filed on behalf of the collector cannot be held to be sufficient compliance with the requirement of the law. The job of the collector in terms of censorship would be over once he submits his report. The land acquisition collector would not know the contents of the proceeding before the state, and therefore he would not be competent to affirm an affidavit on its behalf. So collector is not. Here collector is filing, state is not filing. If the state do not file, the inference is there that they have dictated and they have a order for review and their own order is there. So my humble submission is, my lord, is a case where, my lord, collector has under pressure has review without jurisdiction. The finality of the award cannot be reviewed by the collector. Therefore, the lordship may kindly consider the prayer made in the writ petition and issued suitable direction, my lord. And subject to, my lord, further after HA and other my colleague, I may give a short rejoinder.
Lordship, kindly see page the award, so-called award, my lord, because that is the entire fulcrum of the case. 4523, my lord. My friend should have been fair to this court and to us, my lord. If he has read that, he should have read the second paragraph of 4523, my lord. Page 76, my lord. Because that would have saved the time of the court and mine also. Lordship, kindly see, this is 4/5/2023 is supposedly award under Section 37 of Compensation Act, Land Compensation Act. Hearing so and so, prepare the draft award, my lord.
Yes.
So it is a draft award which is prepared, my lord. It is a draft. Now my friend says that it is a final award.
Yes.
He should have shown this paragraph. This is a draft award. It is not a final award. So entire case is that what is final award? Final award is under Section 37, my lord. That was, my lord, not filed before your lordship.
It is there?
Yes, my lord. I have the final award, my lord.
It's not been filed by affidavit?
My lord, I have got the, because I saw in the RTI, my lord. In RTI also they have the final award. They have in the RTI also, your lordship will see kindly 2 pages of the RTI. That is why I wanted to show 2 pages, my lord. Kindly see 348, my lord. 348 RTI. .348, my lord, page 348. 348. Kindly see the RTI.
RTI application.
RTI application, paragraph 6, my lord, at page 349.
Yes.
Copy of the draft award sheet dated 4/5/2023. And your lordship will see query, paragraph 11, query number 11, copy of the final award. So petitioners know that the award of 4/5/2023 is draft award, my lord. So why so much hue and cry on final award, my lord? If that was the final award, why did my friend's client say it is a draft award, my lord? 2 pages I just wanted to show, my lord. 2 pages, and my lord, kindly see the award also, my lord. That is dated after all the exercise between the parties, my lord, 19th February.
You have to file it by affidavit.
I'll file affidavit by way of affidavit. Now, my lord, kindly see 37.
They should have an X in the entire affidavit.
You should have an X. They have got it. They have got it, my lord. They have got it. It's there.
So we're not going to take accusations of he doesn't have.
Yes, my lord. But it is their whole case based on why did they say that it is a final award when they are treating it as a draft award? Why did not they make any averment, my lord?
Then
we're not treating for draft.
Why did not they make the averment, my lord?
You file it.
I'll file, my lord.
We'll conclude day after tomorrow.
Yes, my lord.
Today is Tuesday.
Yes, today. Day after tomorrow, my lord.
Wednesday.
My lord, 19th, your lordship will kindly see, this is a 19th February, your lordship will see, next page, my lord. 6, name of the persons. Name of the persons interested in the land acquired is Swibert, Nongrang, and 487, and date is 19th February, and 24th February onwards, they have started receiving the money. That your lordship, my friend has been kind enough to show that page.
That's okay.
So they have.
Please, this is 19th February 2024.
Yes, my lord, final. That is 3rd May.
That is 4/5/23.
Yes, my lord.
Is the. Yes, is the.
If your lordship will see.
What happened within this prepared draft award and this? That is still.
So what has happened, my lord? No, I will just explain what has happened, my lord. There was a draft award which was circulated between the government and interested parties, land acquiring agencies. Land acquiring agencies said that this is my budget. This is this final. If you have, you are willing to give me land on this price, you give me the award. The money was accepted under without protest, my lord. Your lordship will see section 76.
But there are judgments, I think, that say even if the formal protest under the old act was not made at the time of asking for section 18 reference, there is still provision
that was there. But in the new act, my lord, can you see section 76, my lord?
It's not there anymore now.
No, it is not there.
There some judgment also there.
Yes, my lord.
Yes.
77 subsection 2, my lord. Proviso is there, my lord. Provided any person who has received the amount otherwise than under the protest shall be entitled to make any application under sections.
You file affidavit, will have
yes,
the affidavit.
I'll place the affidavit.
A copy of the final award statement has.
In both the cases, I will file the affidavit, my lord.
Dealer Advocate General, stop the same not on record before this court. Directed to file the same with affidavit. Just the after tomorrow.
Yes, my lord.
At least I've recorded your submissions in this one page.
It might have been grateful, but let him find.
But only one concern of the court is I hope that the real people whose lands have been taken have received the compensation.
Deprived.
Not some big land shark who's,
Yes.
Did they have received?
And my lord, we have got now.
That is because the other writ petitions pending in this court where there's been a lot of impersonation and that is only concern because fine, well and good, a huge amount of money is going, valuable land being parted with.
Exactly.
When but then I just hope it's just an observation of the court. I just hope that in but that amount was shocking that one person gets 81 crores.
But out of the record, my lord, outside the court, those accusations are there. But indeed, my lord, the landowners they themselves receive through their bank account. Nowadays, under the new act, they don't allow to receive by the attorney holder.
The government has to take more care, like with regard to exact, determination.
Lord, now
they transfer through RTGS,
through bank account. Now expressway is coming, and out of 100 kilometers in Meghalaya, and minimum budget is 20,000 crore rupees, my lord. So then again, huge.
More work for Mr. Changre, sir.
In other states, my lord, the government spend thousands of crores for highway.
20,000 crore.
But for in the tribal states, when they sanction for 600, 800 crores, it seems it is too big.
Which one?
But other states like Mumbai, they spend thousands of crores for highway constructions. For the Northeast, when they sanction 1,000 crore, 500 crores.
20,000 crore.
Ministry. Yes.
Objection.
Other matters, connected matters, they are for tomorrow. That is 5 to 7, 11 to 13, and 24. Yes. Yes.
Please, Lordship. Lordship is supposed to file rejoinder. Item number 8 and item number 8 and I connected matter was supposed to file rejoinder. Yes, Your Lordship. Bring forward.
2 weeks as prayed for rejoinder. Allowed.
10.
We require some more time to file the rejoinder, Lordship.
2 weeks.
Okay.
Yes. Same order. Yes.
Fourteen.
This matters for evidence.
No, Your Lordship. Hearing on 711, Your Lordship.
Where's the petition? You ready?
Lordship, the applicant in the application of Order 7 Rule 11 have to start, Your Lordship.
You ready?
My colleague is coming, Lordship.
Which colleague?
Mr. A.S. Pandey, Lordship. He is conducting the...
The same matter regarding that perjury?
Lordship.
Perjury also?
No, Lordship.
Yes.
This is not perjury. This is the 711 application, my lords. It was
pending now also.
Yes,
well as it is.
It was. You have to reply.
My lords, I have to start. My learned friend has already placed the objections, my lords.
Gotten everything, Mr. Paul.
Yes.
What is your substantial objections? Presentation.
Non-compliance of 81 minutes.
Well, as far as this case is, if I can briefly recapitulate as
with other orders passed, this could cover this case also.
Yes,
well, it would. That's what I had said. But my learned friend had raised these issues, my lords. But we can answer that, my lords, because as your lordships will be aware, my lords, the Honorable Supreme Court formulated a principle called the doctrine of substantial compliance, which would be applicable in election matters. I can place that, my lords.
So briefly, my lords, if I can recapitulate as to what happened in this case. There have been other orders as far as section 81 is concerned. And my objections are also on the aspect of presentation of the election petition. But to that limited extent, that will require some amount of evidence. that whether the presentation has happened or not, and your lordship has already taken a view in those matters. So similar view will be taken in this matter. So I need not, my lords.
You don't press it, then we'll go for evidence.
No, on that aspect, my lords, an evidence may or may not be.
We'll find other part you want to dismiss.
There is another part to it. So, my lords, kindly have section 81(3).
One thing, Mr. Paul, before he commences.
I'm sorry, Millet.
Is the election petition interested?
Millet.
Or is going through his motion?
No, Millet. He wants to. This matter he wants to pursue.
Yes.
You sought specific instructions, Millet. It should not be a case of abandoning the matter after my lords have heard the matter at length.
Yes. Copies.
Yes, my lords, section 81(3). Yes, my lords, every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such copy shall be attested by the petitioner under his own signature to be a true
I remember.
copy.
Now I think that there's no authorization or no notarization
Yes,
on the
ma'am.
subsequent pages or something like that.
Yes, my lords. So here what has happened is, interestingly, I have put both the petitions, the one which was served upon me and the certified copy which has been obtained from the records of this honorable court. And there is, my lords, a sea of difference in both the petitions. So if your lordships, I can take to my application under Order 7 Rule 11 read with section 86 of the Representation of People's Act, and directly, my lords, if I can take your lordship to page 20
Of the application.
of my application,
Yes.
which is Annexure 1, and it is the copy of the petition which has been served upon the respondent.
21.
Page 20 or 21? Page 21.
Page 21. Yes, well, and then I think the relevant page would be page 28. Where the petition starts.
Yes. This is the certified copy you obtained.
This
It was
is
not served upon you.
served upon me, my lord. And
yes,
your lordship notes the stamp of the notary. The notary stamp is that of Mr. J.F. Blah. And my lords, towards the left hand side there is the instrument number mentioned of the notary 2 of 13/4/2023.
Yes.
So the notary stamp, my lords, continues to the next page and the page thereafter.
Yes.
Of Mr. J.F. Blah. Then
It's absent from page 4.
page 4, my lords, even the notary stamp
So
is
up to page no. Okay.
so thereafter the notary stamp is absent in the entire petition. The election petition has to be attested and verified to be attested by the notary. Now there is no notary stamp, and thereafter, my lords, it again resurfaces itself on page 48, which is the verification page.
Yes.
None of the pages which have been served upon me.
49. Yes. Okay.
Yes, my lord. There is, I think, there is a page difference of one page. I don't know, maybe. So for, and then, my lord, it surfaces on the verification and the affidavit page.
Yes.
But it is absent for a large chunk of the petition. The large chunk of the petition does not even say that it's a true copy of the original election petition, creating even further doubt in the minds of the respondent.
Yes.
Thereafter, well, also the annexures start. Annexures are also supposed to be notarized. True copy. None of the annexures have been notarized. there is an attestation by the advocate saying that it is a true copy at the bottom.
Yes.
Which is also not as per the Act and the rules. And this continues till the end of this petition. So none of the annexures have been notarized. These signatures, I do not know whether these are the signatures or who has signed it. Those aspects have not been formally complied in filing of the election petition. Now, interestingly, my lords, once this petition ends, your lordship will find at page 85 the petition that I received from the records of this honorable court has been annexed as annexure 2.
I think page 86.
86, my lord, it must be, there is one page difference, so 86.
Just a CC copy.
Yes, my lord. Now, interestingly, my lords,
yes,
in this petition, your lordship notes the notary stamp. The notary stamp is that not of Mr. J.F. Blah. It is of one Miss Melarica Lingua.
Okay.
Having a different notary stamp and the instrument, my lords. Number. So the act of notarization, I have to be served as the exact copy which has been filed with your lordships. And after it has been filed, you go to the notary with a different copy or whatever and get it notarized and serve it upon me. That is not compliance of section 81(3). And this also copy, my lords, which has been filed, only 2 or 3 pages of notarization, and then remaining parts have been have not been notarized.
Yes. Yes. Yes.
So, my lords, in my humble submission, that this, firstly, the copy is not being entirely notarized. The notary's stamp being that of a person who's different, it's a different copy altogether.
Yes. Yes. Carry on.
And my lords, the annexures which have been filed have not been notarized.
Yes.
The annexures have been affirmed to be a true copy by the advocate.
Yes.
The petition served upon me does not even bear that attestation that it's a true copy. So, so all these points, my lords, goes on to show that section 81(3) has not been complied.
Yes.
And my lords, in this regard, my lords, last time when I had argued the matter, I had placed one judgment of the Guwahati High Court.
2022 GLR.
Yes, my lords.
Yes.
Yes, my lords. Just a few paragraphs of those. It's a very brief judgment, my lords. There's a few paragraphs of that judgment.
Yes.
Can you just give me the citation?
It is 2022 to Guwahati Law Reports 223.
Paragraphs 10, 11.
Yes, my lords.
I made small notings earlier on, that's why.
Yes.
Where is this?
I just placed, my lords, paragraph 3 also, the brief facts of the matter, because there is some amount of casuality which has been adopted in
election petitions.
In election petitions and in the act of notarization, which has been noted in this. So when the matter came up for consideration while preparing the judgment, I have noticed that respondent claimant number 1, Aarti Boro, while submitting her evidence on affidavit sworn before notary Kamaroop, she did not put her signature on the evidence on affidavit. Her witness Jeetu Boru, who was examined in MAC case number so and so as PW2, also did not put his signature in his evidence on affidavit. But it is interesting to note that the notary put her signature with seal accordingly on each page of the evidence on affidavit of PW1 and PW2 in MACC case number so and so. It transpires that PW1 claimant in the MAC case number so and so as well as PW2 did not appear before the notary Kamrup for the purpose of their evidence on affidavit. Perhaps the matter has been overlooked by the learned counsel for the both sides and the learned tribunal who had delivered the judgment on 23 March 2017. So it reveals from the MAC case that one additional affidavit has been filed by the respondent claimant on 24/1/2017, wherein she put her signature on each page of the affidavit, but in the said affidavit she did not utter a single word that she had failed to put her signature on her earlier affidavit. This is, my lords, the facts, and then I will take your lordships to para 6. As per the Notaries Act or the Oaths Act, the notaries or the oath commissioners are required to follow the rules carefully in administering oath and affirmation. The act should not be done in a casual or incomplete manner, giving room for an impression that the affidavit has been attested in the absence of the deponent, or that the affidavit has been attested on a day other than the day on which it was signed by the deponent, or that the transaction has not been entered in the oath register. The rules have been framed precisely to safeguard against such contingencies and to ensure that such mistakes do not occur. Thereafter, my lords, sees para 10. Section 8E of the Notaries Act 1952 empowers a notary to administer oath or to take affidavit from any person under Rule 11.2 of the Notaries Rules 1956, requires a notary to maintain a notarial register showing serial number, date, nature of the notarial act, name of the executant or person concerned with full address, contents of the document, notarial fee stamp, a fixed fee prescribed and fee charge, serial number of the receipt book. The notary is also required to obtain signature of the person who is executing the document in the register. So this act in my case was done by Mr. J.F. Pla, and the petition bills which has been served upon your lordship, that has been done by Ms. Mallarika Lingua. So that's a completely different act, 11 bills. Thus, when a notary oath commissioner administers an oath affirmation, he is mandatorily required to enter the name and the particulars as prescribed and obtain the signature of the deponent in their registers. Such entries are required to be made in seriation by assigning a separate serial number for each transaction. The prescribed procedure for attesting affidavits makes it clear that making of endorsements on the affidavit and recording the particulars and obtaining the signatures in the register is an integral part of an act of attestation or act of administering oath or affirmation. It therefore follows that while making necessary endorsements in the affidavit, the attesting officer will have to mention the reference number of the transaction as entered in the register in the endorsement made at the end of the affidavit. It is also necessary that the attesting officer should mention his address to show that the place where the affidavit is attested. Mentioning the serial number of the transaction as entered in the register in the affidavit while making the endorsement of attestation is the only way of ensuring that a record of attestation is maintained by the oath commissioner notary. Unless the transaction particulars are entered and the signatures are affixed in the register as required, and the serial number of the transaction in the register and the place of attestation are mentioned in the endorsement made, the act of administration oath will be incomplete, and it cannot be said that in such circumstances the affidavit is duly attested. It will be a defective affidavit. The courts will not act on defective affidavits which are not attested in the manner required by law. So there are two aspects. One, the integral part of the notarization, Milord, and the second aspect is even the affidavits which have been submitted, 2 pages notarized and thereafter remaining petition not notarized, the annexures not notarized, will not amount to be attestation. So that, my lords, that is my submission. And just, my lords, buttressing my argument by a recent judgment of the Gujarat High Court, my lords.
Yes, please.
Thank you.
Legal orders. Yes.
So, my lords, in this case, now the situation is, my lords, much water has already flown in this matter, and all these aspects, my lords, have to be cured within the period of 45 days of filing of the election petition. So if these aspects are noted and there are certain defects, then they have to be corrected within a period of 45 days. That, my lords, para 10 is the issues in this matter.
Yes.
So the issues are, my lords, considering the submissions and counter submissions made by the learned advocates appearing for the respective parties, the issue which arises for determination of this court is whether the election petition is barred by limitation and is liable to be rejected under Order 7 Rule 11D of the court, for office objections were removed beyond the limitation period of 45 days. For deciding the above issue, the provisions of the Act 1951 as well as 1993 rules and judgments are worth referring to. Thereafter, my lords, the provisions have been quoted, but directly, my lords, I will take your lordship to para 18, where the contentions have been noted.
When was the judgment passed?
My lords, this has been passed. It's a very recent judgment, and the SLP against this judgment has also been rejected. So this, my lords, has been pronounced on 7th February 2025.
Where do you get the date from?
First page, my lords. First page, top.
Right on top.
Yes.
Oh, yes.
Top right.
Yes.
Para 18, my lords.
Yes.
Adverting to the facts, the captioned application has been filed by the applicant, original respondent inter alia, praying for rejection of the election petition in accordance with provisions of Order 7 Rule 11 of the court, read with provisions of the Act of 1951 as well as rules of 1993. The first and the foremost objection is that the election petition, though is required to be presented within 45 days of declaration of result, it has been registered much after the expiry of 45 days, hence is barred by limitation. The second objection is that joining respondents 1, 4, 21 and 22 would be barred, and the election petition should be rejected only on the ground of misjoinder of parties. Further objection is that the election petition, though is required to be accompanied by as many copies thereof as there are respondents mentioned in the petition, every such copy shall be attested by the petitioner under his own signature to be a true copy of the petition. The copy of the election petition served upon the applicant, original respondent, is neither verified or signed to be the true copy of the election petition required under subsection 3 of section 81 of Act of 1951. Objection is also raised as regards non-providence of material facts and particulars in a concise statement as required as per provisions of section 83 of the Act of 1951, so as to prove that the result is materially affected, hence no cause of action is available. Objection is also raised about the suppression of material fact and deposit of 2000 rupees only after the limitation period, hence the provisions of section 117 of the 1950 Act also the petition fails. So, my lords, that is the my lords, the contention. Then para 21 are the para 21 are the contentions, my lord, noted in this regard, and reference has been made to the Supreme Court judgment of Satyanarayan versus Dujaram 1974 4 SCC 237. And I'll just read the quoted part on the subsequent page, please. Keeping in mind keeping in the forefront the proper functioning of democracy, the principal object of the Act is purity of elections. When therefore an election of a returned candidate is challenged under the Act, expeditious trial of the election dispute is sought to be enforced by the legislature, making all safeguard against delay. Trial has to be necessarily expedited to rid the candidate as well as the constituency interested in the result of the election of any taint of suspicion of corrupt practices which are again clearly enunciated in the Act. To take therefore another important object of the Act, expeditious disposal of the election petition under section 86(6), the trial of an election petition in the interest of election petition shall, as far as practicable, consistently with the interest of justice is respectable. That is not last part. If your lordship sees of that paragraph, therefore
there's no scope.
Therefore, there is no scope for free play in the application for the provisions of those two acts. The very object of expeditious trial will be defeated if the presentation of the election petition should be treated casually and lightly, permitting all kinds of devices to delay the ultimate trial. The purpose of enclosing the copies of the election petition for all the respondents is to enable quick dispatch of the notice with contents of the allegations for service on the respondent or the respondent, so that there is no delay in the trial at this very initial stage when the election petition is presented. If there is any halt or arrest in the progress of the case, the object will be completely frustrated. We are therefore clearly of the opinion that first paragraph of 81(3), which we are mainly concerned in this appeal, is a preemptory provision, and total non-compliance with the same will entail dismissal under section 86 of the Act. So, Milos, that is the purpose and last part of this Milos judgment at para 32. While respectfully, para 32 minutes, last page. While respectfully agreeing with the view taken by the coordinate bench as well as the Bombay High Court, this court is of the opinion there is no provision which confers any power upon the registrar or any officer authorized by him to permit the correction or removal of the objection in an election petition beyond the period of 45 days. Undisputably, the facts are discussed and the petition is dismissed. So now, Milods, after 45 days, basically there is some sort of a closure in respect of the election petition, whatever it is on the 45 day, that is the petition. And today we have a situation where the election petition filed with your lordship is at a complete departure with the election petition which has been served upon me. So that is my summation.
How long will it take, Mr. Paul?
15-20 minutes.
Us will continue tomorrow. You reply tomorrow.
I am not available tomorrow day after.
Then we want to.
I'll try and make it concise.
I don't think you'll finish in 15-20 minutes.
I'll try and make it concise. I'll just place the law.
If you're talking about substantive compliance, yes.
Well, I'll just place the law.
Yes.
Because whatever objections, what my learned friend, if I may very quickly take my lords to page 3, paragraph 6
of your petition, of their petition.
My lords, why I'm craving this indulgence is my lords have already heard us at length at one occasion. Well, if the matter again gets delayed today, all of us will forget.
Yes.
Para 6 is, my lords, the substantial objections that have been taken by the respondent, my lords.
Yes.
Page 3, paragraph 6, my lords have it. There's that without prejudice to the grounds taken above, the petition is also barred inter alia on the following grounds. The petition is barred by law as it has inter alia been filed in a violation of section 81 of the Representation of People's Act 1951, which my learned friend just read. The petition is filed against Rule 1 of Chapter 8A of the Guwahati High Court rules as adopted by the Guwahati High Court of Meghalaya. Petition is filed in violation of section 82 of the Representation of People's Act. The petition is filed against 83 of the Representation of People's Act. The petition is filed in violation of Order 7, Rule 11 of the Code of Civil Procedure 1908. These are essentially the substantial, my lords, objections that they have taken. Now, the first objection which my learned friend has now placed, my lords, is with regard to the notarization of this particular petition, my lords. The first issue that comes in is, my lords are now dealing with this matter as if it is a civil suit. And my lords are now constrained to, my lords, only deal with objections which are otherwise amenable for consideration under Order 7, Rule 11. So, if I may first take your lordships to Order 7, Rule 11, CPC. My lords have it, my lords.
Yes.
Rejection of plaint.
Rejection of plaint. Yes.
My lords, A, where it does not disclose a cause of action, definitely not. Whether relief claimed is undervalued, not necessary, my lords. Whether relief claimed is properly valued and the plaint is written upon paper insufficiently stamped, not relevant. Where the suit appears from a statement in the plaint to be barred by any law, this, my lords, may be one of the grounds. Where it is not filed in duplicate, where the plaint fails to comply with the provisions of Order 9, not relevant for our purposes. So, my lords would kindly see that there would have to be a specific bar in law for the purposes of, my lords, exercising the power under Order 7, Rule 11 of the Code of Civil Procedure. Now, the bar which they are talking about, my lords, is emanating from the Representation of People's Act.
81(3). Yes.
So, first, my lords, if I'm just permitted to take your lordships to Section 81. My lords have it?
Yes.
81(3), my lords, to be specific. Now, if I may read, my lords, 81(3). Every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such copy shall be attested by the petitioner under his own signature to be a true copy of the petition. So, there are two requirements, my lords, under subsection 3. A, my lords, that there has to be as many copies of the election petition which has to be filed along with the originals. B, my lords, that every copy has to be attested under the signature of the election petitioner. These are the only two requirements. Now, if I can understand what my learned friend is arguing, my lords, is he's saying that the notarization is incorrect. That may be a case under the Notaries Act, which my learned friend has placed a judgment of the Honorable Guwahati High Court in the Notaries Act. That per se, my lords, doesn't come as a bar under 81(3). Even assuming, for the sake of arguments, my lords, what he's saying is correct. Even if it is not notarized, that is not a requirement of law. Requirement of law is there must be as many copies, A. B, every copy has to be signed by the election petitioner with true copy, as a true copy. These are the only true requirements under 81(3). Now, if we go back to, my lords, the election petition and the copies which my learned friend is talking about, from page 29 onwards.
Yes.
So this, my lords, is page 29 onwards is the copy that apparently my friend has received. My friend's client has received, my lords. On the right hand side, my lords, will kindly see Ali Akbar.
Yes.
Every page, my lords, without fail is signed by the petitioner in person.
And accused too.
My lords. Page 67, we can just randomly go through some pages, my lords. 67, your lordships would see. Then, my lords, 68, again on the signatures, sometimes on the right hand side, my lords, it's there. So it is signed by the petitioner.
So you see this this
now the copy that the copy that my lords they have obtained from this honorable court is on the next annexure. Your lordships will see it's the same signature, Ali Akbar. Now, therefore, the question that arises, my lords, and which I'll place the law on that is, what is the requirement of Section 81, and what would tantamount to substantial compliance?
Yes.
So the requirement of law is, my lords, not a notarial stamp. The requirement of law is that the petitioner has to sign on every page of the document.
Yes.
Now, if that is not there, my lords, of course, 81(3) will be attracted. That is not the case here.
Yes.
In this regard, my lords, I'll just place two judgments very quickly, my lords. We've served a copy. Copy for them. This is a compilation. We've prepared a short compilation of all judgments, my lords, to save the time of this honorable court. Well, the first judgment is of Murarka Radhe. This is, my lords, I'll give the SEC citation they've given the. This is, my lords, of a constitutional bench of 5 judges. It would be AIR 1963 online SC 129, but online will not be, my lords, 64(3) SCR 573 would be the relevant citation. The relevant paragraph, my lords. If my lords kindly quickly come to paragraph 11 at page 8.
Yes.
My lords have it.
Yes.
We agree with the High Court and the Election Tribunal that the first defect is not a defect at all, where every page of the copy served on the appellant was attested to be a true copy under the signature of the petitioner. A fresh signature below the word petitioner was not necessary. Subsection 3 of Section 81 requires that the copy shall be attested by the petitioner under his own signature, and this was done. As to the second defect, the question really turns out to on the true scope and effect of the word copy occurring in subsection 3 of Section 81. On behalf of the appellant, the argument is that subsection 3 of Section 81 being mandatory in nature, all the requirements of the subsection must strictly be complied with, and the word copy must be taken to be an absolute exact transcript of the original. On behalf of the respondents, the contention is the word copy means that which comes so near to the original as to give every person seeing it the idea created by the original. Alternatively, the argument is that the last part of subsection 3 dealing with copy is merely directive, and for this reliance is placed on the court decision of this court in Karmraj Nadar versus so-and-so. We are of the view that the word copy in subsection 3 of section 81 does not mean an absolute exact copy, but means that the copy shall be so true that nobody can possibly misunderstand it. In view of the matter, it is unnecessary to go further into the question whether any part of subsection 3 of section 81 is merely directory. That aspect, my lords, is the second argument, which at this stage may not be necessary for my lords also to go into, because it is directory, it's not mandatory. So the compliance has to be, my lords, that every page of my copy which has been served on the election petitioner, on the respondent, my lords, must bear the signature of the election petitioner. As long as, my lords, the signature of the election petitioner is there, there is compliance of subsection 3 of section 81.
Yes.
So, irrespective of the fact, my lords, that whether it is notarized, whether it is not notarized, whether it is signed by one notary and not by the other notary, my lords, would be an issue that would be dealt with by my lords.
What would be a true copy then?
I'm sorry, my lords.
What would be a true copy then?
I'm sorry, my
What
lords.
would be a true copy?
A true copy is a copy, my lords, of the exact petition along with signatures.
Not a true copy.
Anything appearing, my lords, anything appearing additionally. I'll place that also, my lords.
What will true copy mean? Whatever are the additions made to the petition in by office noting or
stamps, etc., my lords, which is not necessary. I'll place the law.
That will not be a true copy.
That I'm pleased. That does not come within the reason of copy. Copy is, my lords, the petition, the contents of the petition have to be same, and they have to be signed by the petitioner. These are the two requirements, the twin requirements of law.
That will satisfy true copy.
Yes.
Okay. Yes.
Because here, my lords, one of the objections is that what has happened is election petitioner has signed, Also, my lords, counsel has signed a certified to be true copy. So there are two signatures appearing. That aspect is also dealt with.
So your main argument is that it is of substance or of form?
It is of substance.
And not of form?
That's why, my lords, the doctrine has been framed.
Of substance or of form?
My lords. It has to be of substantial compliance.
No, substance not of form. I mean, like the form matter, but
form is of may not be of relevance. If I may put
stamps and the other additions or embellishments,
these are other issues, my lords. These are other issues. And like I said, my lords, that issue, if at all, if I take, my lords, this has not been argued by my friend, but if the argument is, my lords, that there is a defect in the oath affirmation of this petition, that also, my lords, will have to consider separately at a separate stage of the trial. It cannot be considered at the stage of 711.
Okay, yes.
711, as your lordships are aware, is, my lords, shutting the doors on the plaintiff at the initial stage, saying that there is a bar of law, so therefore you cannot even come in.
Yes.
Well, it's the second important, where this entire doctrine of substantial compliance comes in is, well, the second judgment, 1999 4 SCC, page 274. My lords will find that at page 13 onwards.
Yes. Then head note itself.
My lords. I take your lordships to the relevant portion. Paragraph. Sorry? 13. 30.
13.
My lords. 30, my lords. Well, I can start reading for 30. The precise objection of Mr. So-and-so learned senior counsel based on section 81(3) of the Act as already noticed as the true copy of the affidavit filed in support of the allegations of corrupt practice and form so-and-so required by Rule 94A. Paragraph 30, my lords, at page 26.
Oh, it's at page 30. Okay.
30.
Paragraph 30.
My lords.
Okay. Right. Harish Salve, yes.
The precise objections of Mr. Harish Salve, learned senior counsel, based on section 81(3) of the Act, as already noticed, is that the true copy of the affidavit filed in support of the allegations of corrupt practice in form so-and-so, as required by Rule 94A, has not been served on the appellant, inasmuch as the copy served on the appellant, the name of other particulars of the notary, and the seal and stamp of the notary, which has been affixed on the affidavit filed along with the election petition, were conspicuous by their absence. Same case, my lords. According to Mr. Salve, the variation between the affidavit filed by the election petition in support of the allegations of corrupt practice and the copy served on the appellant had rendered the copy as not a true copy of the original. And notwithstanding the difference between Dr. Shipra's case and the present one, the election petition ought to have been dismissed for non-compliance with section 81(3) of the Act. For what follows, we are persuaded to agree. For what follows, we are not persuaded to agree. Section 81 of the Act deals with the presentation of an election petition. Subsection 1 of Section 81 provides that an election petition calling into question an election may be presented on one or more of the grounds specified in Section 101 and Section 101 to the High Court by any candidate at such election or any other elector within 45 days from the date of election of the returned candidate. Some of the relevant provisions are so-and-so. I'll skip this.
We come to 33.
33 millions. Does the word copy occurring in section 81 of 3 of the Act mean an absolute exact copy, or does it mean a copy so true that nobody could by any possibility misunderstand it? The matter is no longer res integra. In Murarka Radhesham Ramkumar versus Rupkumar Rathore, a constitution bench of this court elaborately dealt with this question, and after referring to a catena of authorities, it was held that the test to determine whether a copy was a true one or not was to find out whether any variation from the original was calculated to mislead a reasonable person. The Constitution bench found as untenable the contention that since the copies of the petition served on the returned candidate did not contain the signatures of the petitioner below the word petitioner, or on the copies of the petition served on the respondent had ceased to be true copies of the original petition, attracting the consequences of section 86(1) of the Act. The bench opined, Melons, I had already placed this. Sorry? Well, it's para 35, if my lords kindly have a look. The object of serving a true copy of an election petition and the affidavit filed in support of the allegations of corrupt practice on the respondent to the election petition is to enable the respondent to understand the charge against him so that he can effectively meet the same in the written statement and prepare his defense. The requirement is thus of substance and not of form. This is exactly what fell for my lords. The expression copy in section 81(3) of the Act, in our opinion, means a copy which is substantially so and which does not contain any material or substantial variation of a vital nature as could possibly mislead a reasonable person to understand and meet the charges allegations made against him in the election petition. Indeed, a copy which differs in material particulars from the original cannot be treated as a true copy of the original within the meaning of section 81(3) of the Act, and the vital defect cannot be permitted to be cured after expiry of the period of limitation. That would cover the second judgment which my learned friend has placed. So, my humble submission would be this law as it is summarized is.
Yes.
My lords, just bear with me for a second, Billets. Millets, and this judgment of 1994, Millets, which I am again placing before your lordships, is again of a constitution bench. 5 judges. My lords would find out at page 13.
1994.
Millets. The judgment I am placing now before your lordships, T.M. Jacob.
Yes, it's 1999.
Oh, I'm sorry, Millets. 1999 4 SSC.
Yes.
So, Millets, the law as it stands is, Millets, what fell for my lords, and I stand corrected, Millets, the requirement is of substance and not of form.
Yes.
So, if in substance, Millets, the copy which has been filed before this court and the copy which has been served on the respondent are the same, ancillary markings of stamps, etc., Millets, will not attract 81(3).
Yes. Anything else?
Which one? Third judgment. Millets. Another judgment, Millets, if my lords kindly have a look at Millets 2001 8 SCC page 358, relevant paragraph, relevant page is page 41.
Punjathang.
Millets.
Para?
Well, this paragraph 14 at page 51, Millets. This deals with this issue of this notary.
3 judges.
Millets.
Yes. Para
14.
14,
4 Millets. Having laid down the law as stated above, the court in Jacob's case, Millets, what I just placed before your lordships, 1999, proceeded to apply the same to the facts of that case and came to the conclusion that non-mention of the name of the notary or in the absence of the stamp and seal of the notary in the otherwise true copy supplied to the appellant could not be construed to be an omission or variation of a vital nature, and the defect, if at all, could be construed as a defect not attracting the consequences under section 86(1) of the Act. It further held that under the circumstances, it must be held that there was no failure on the part of the election petitioner to comply with the last part of subsection 3 of section 81 of the Act. Hence, 86(1) was not attracted, entailing the dismissal of the election petition. So, there is clarification on Jacob, Millets, in this. Insofar as this aspect of the matter is concerned, Millets, matter comes to an end over here. The other objection which my learned friends have taken, Millets, in the 711 application deals with the non-presentation by the election petitioner before this court. That would be covered by lords by the judgment delivered by my lords in the other election matters, where your lordships have said that that could at the best be tried as a preliminary issue.
Yes.
So the 711, my lords, essentially has to fail. The one other aspect is, my lords, since, my lords, we are going into procedure, and my learned friend has, my lords, said that Now, the question is, they say that there is non-compliance of 86.1, the High Court rules. There is also a lot of emphasis played on the fact that it is non-compliant of the Guwahati High Court rules. I draw your Lordship's attention to Rule 10.
Aye.
Show the order sheet. I think it's the same book, my lords. May find it at page 89.
Chapter 8.
Yes. 8A, my lords. Page 89.
The applications.
My lords.
Yes.
Rule 10, my lords, upon it. All interlocutory applications petition should bear the court fee of ₹6 and thereon, and may be filed before the judge with permission of his lordships. I am on the second part, my lords, with permission of my lords. Now I'll take my lords to the order sheet in this election petition. Well, as this matter was originally moved on 19/4/2023.
Yes.
My lords had issued notice. 11/5/2023, my lords, Hajira filed by the petitioner indicating presence in court. Office note indicates the service report in respect of respondent is not yet received. List the matter on 15/6/2023 to await the service report and appearance of the respondent. Then, my lords, is the important order of 15/6/2023.
Yes.
Ms. S.K. Nongrum, Learned Counsel, has entered appearance today on behalf of the respondent and prays 3 weeks' time for filing written statement. Prayer is allowed. List this matter on 10/7/2023 for written statement. Next order, my lords, may kindly look at 10/7/2023. Seen the application under Order 7, Rule 11, filed by the returned candidate, Mr. So-and-so prays that he may be allowed 2 weeks' time to file objection. Prayer is allowed. My lords, the prayer before your lordships was made to file written statement. This application in the first place could not have been entertained in view of the embargo under Rule 10. If I have to file an application of, my lords, an objection.
Objection on record in the objection to.
Yes, my lords, we have. Yes. We have. So this application itself has been initiated without leave of this court.
Yes.
So if, my lords, that is the case, this objection in the first place had to be thrown out only on that ground.
Yes. Yes. Anything else?
It's on the same issues, because the law has crystallized since, that it has to be of substantial compliance and not of absolute compliance.
You want to make a reply?
I'll reply, my lords, but I'll seek some time, my lords, for the rejoinder. But the essential issue which has been raised by the learned senior counsel.
Substance, not form.
Substance, not form.
Yes.
But there are none of the judgments which I could see in the compilation where a different document itself has been served upon to the election.
What are you supposed to do?
My lords, I will reply. I will reply to the judgments which have been cited, my lords. And even as per these, my lords, may give me some time because I will place my own authorities on these issues.
The only issue is, my lords, I must clarify here that if I can understand correctly what my learned friend's objection is, that there are two separate documents. It's not a question of two separate documents. To clarify myself, my lords, it's a question of same document bearing different markings, if at all.
No, he said that's a base of his contention is that the copy served upon him and the copy filed before the court
have different markings.
Have different markings or are different copies.
No,
yes.
That's
his contention.
I'm saying that have different markings. To that extent, my lords, I had said that for the sake of argument, I concede. Even on that, my lords, that is the law. In substance, the petition, what is there, my lords, filed and what is served is the same.
10 days?
I will not be here, my lords. So
the courts are the mercy. That's what happens again. Yes, this is okay. Replies by the counsel for the applicant.
Yes,
to be fixed on. Give a date.
23rd, my lords.
Court's always here.
23rd, my lords.
23rd. August or July.
15.
Obliged.
Obliged.
15, 16, 17. Plus, these are the three contempt matters from that nectar matter. Now, there's been a development in this, my lord's order has been upheld by the division bench.
So we'll close them or leave them?
No, my lords, they have not complied.
They've already been reinstated, correct?
No, my lords.
Yes.
Please, Your Lordship. Lordship, kindly place this matter at the end of the board. The DSGI is on legs and he has some submissions to make, Lordship.
Submission regarding contempt will follow if the division bench. Can you just produce order of the division bench?
My lords, wait.
It's only been the judgment pronounced.
My lords, yesterday as well.
Where's the operative part?
My lords, I'll just take your lordship from this. If my lords kindly have the last page. For all these reasons, I go even further than the ultimate order passed by the learned single judge, direct reversal of the cancellation of the orders of appointment of the respondents as if they were honest. The respondents are restored to the original appointment by the Director General without interruption by cancellation. They shall be entitled to pay allowances and other benefits without any interruptions. The appeals are dismissed. The writ petitions are disposed of by affirming the order of the learned single judge together with modifications and
What
directions.
remains, Ms. Mirjan?
Your Lordship, the DSGI has some important submissions to make, Lordship. If
Because
you
has
kindly
notice been
have-
issued in this?
My lords, notice has been issued.
We'll have it tomorrow.
Lordship.
You, Mr. Chanda, will be here.
Well, it's
yes, Mr. K. Police and Council has produced a judgment dated 25/6. Oh, sorry, 8/7. 2025 of the Division Bench of this court, wherein the order of a single judge has been upheld. Stop. Next time, Member Chang prays that it might be taken up tomorrow. Pass it for the day. Yes. This tomorrow.
18. 18.
Please, Your Lordship. Lordship, my affidavit is ready. You have sent it for signature. Kindly warn
You're
you.
5 to 8.
5 to 8, Your Lordship.
Yes, Lordship.
Course
In
of
the
the day.
meantime, Lordship, I'll file the rejoinder.
Course of the day. We have sent it for signature.
In course of the day.
We have sent it for signature in
It
governance.
was allowed further 1 week's time.
1 week, Your Lordship.
You have filed affidavit.
Lordship, in the meantime, I'll file the rejoinder
To whom?
to the affidavit filed by the JHADC, Lordship.
Yes, MS Timothy also prays for allowed 2 weeks' time to file a joint of the affidavit filed by JHDC respondents. That is after 2 weeks.
19.
Obliged, Your Lordship.
This matter, my lord, can be fixed for hearing. My lord, in the
You also do
meantime,
the same thing with Thapa. You take time for joinder, and
my
when
lord,
time
only
is
one
elapsed,
respondent,
you say
the other
for hearing.
respondents have my lord, refused to file the affidavit.
Mr.
My lord.
Thapa, Faris pray the matter be raised for hearing.
In the meantime, my lord, will file. In the meantime, my lord, we may be allowed to file the rejoinder. We'll file it before the hearing date is fixed. My lord.
You further praise allowed to file a joinder. In the meantime, it's praise allowed just for hearing on so and so.
20.
Please, Lordship. Lordship, they have filed the affidavit, Your Lordship.
Already filed our
It's a
affidavit.
matter regarding under the POSH Act.
Yes,
Your Lordship.
There's no appellate provision. In
Your Lordship,
the-
they are challenging the maintainability, Your Lordship. I'm praying for 3 weeks' time to file my reply, Your
You're
Lordship.
challenging the
Maintainability of the petition, Your Lordship.
full challenge.
They are challenging.
Why are you challenging it?
They are saying that this matter ought to have been tried in the CAT, Your Lordship, before the CAT.
Is it a service matter or?
Service matter.
This is service matter, madam.
Or is not that matter against sexual harassment?
No, Your Lordship.
No. Yes. At least after 1 week for
3
the
weeks, Your
joinder.
Lordship.
2 weeks.
3 weeks, Your Lordship.
No. Yes, as prayed for the 2 weeks allowed for the joinder. Yes.
21.
This matter will take a little time. Let's have it in the second half, at 2.
You're ready with the matter?
Well, I'm ready. I think my little friend is also ready.
Yes, I am ready.
2:15. 21, 22, these are both those two. Correct.
23.
Affidavit file?
Today, my lord.
I've
You've
received copy. Yes, my
You'll
lord.
file a joinder?
Yes,
no.
my lord. Yes, I will.
As long as it plays for allowed 2 weeks' time. for rejoinder to the affidavit filed by the state respondents. Just for 2 weeks, yes.
Highly obliged. 25.
My lord, I'll need a little time to file my affidavit.
How much time you have been allowed? How
We
many
have
times
not-
you prayed?
This is the second time.
More than second time. Lordship.
You're for 2 and 3. What about
The Deputy Commissioner said he will not be filing the affidavit. They said.
What's the matter about?
Regarding this one, their own admission that they have acquired some portion of land, and then there is a due to be paid to us, and then since the due have not been clear, there is no handling over of the land to the respondent. That's why they now
File affidavit then.
Are we waiting for instructions, my lord? We
You have
haven't
not
got
got
any.
instructions.
No.
Who's the person responsible to give instructions?
MECL.
You summon them?
We have.
in open court?
We have. Oh.
Why not give instructions?
We have asked them twice, my lord.
Why you
We're
ask them
waiting.
twice? So Mr. OI, MS OAI Bank, General Counsel for Respondents 1 and Response 2 and 3 submits that in spite of her efforts, instructions yet to be received from said respondents. Stop. Who is the person responsible?
My lord, we have
Secretary.
it's the law officer out there, but we'll find out.
Expected that however, instead of justice for a 2 weeks time granted affidavit, expected next date affidavit should be on board. Yes.
Lordship.
Otherwise, you summon whoever officers there. Yes.
26.
Mr. Jha, rejoinder file.
My lord requires.
You won't file.
We will file 2 weeks, my lord.
Okay. Let's pray for the 2 weeks time allowed. Yes. The third time.
No, my lord. Second time.
Yes.
This is under lock and key, this shop, and then
It's on lock and key. Who locked it?
both of us.
Both of you locked it then. That's status quo. Very good status quo is there. You locked it. He put the lock on top. So, what better status quo can you have then? That's it. Yes.
27.
Yes.
May it please your lordship, I'm
Where's the
appearing on
affidavit?
behalf of Mr. ML Nongpyo. No lordship, I'm
1
praying
and
for
2.
some
Who's
more
the 1
time.
and 2?
I'm appearing on
Mr.
behalf of
Pandey.
Mr. ML Nongpyo, your lordship, for respondent 1 and 2.
Change counsels.
No lordship, I'm appearing on their behalf, lordship. I'm praying for some more time, lordship.
After 1 week.
2 weeks, lordship.
After 2 weeks.
Fine.
Previous.
28.
Orders, hearing will take up after the second half. Yes.
May it please your lordship. Lordship, I paid for 2 weeks time
You
to
won't
file
file
the
rejoinder?
rejoinder. We'll file your
2
lordship.
days time to file.
2 weeks, your lordship.
How many times you prayed?
This is third time, your lordship.
Third time. Okay. Final opportunity of 2 weeks granted to the petitioner for rejoinder. Yes.
Yeah, but it says they'll ask for time.
Item 21.
Cover hearings.
Well, it's 21 and 22 are those two matters which will come up in the first half. I made a request to take them.
It'll take some time.
Take a little time.
Then what about the other councils, which urgent matter is there? Urgent matter, you can wait, otherwise we'll have to, I don't think it'll be possible.
The only thing is last item, my lord, 47, that golf matter.
You want to update it?
No, my lord, we can have it tomorrow or next
Well, it's
week.
golf, that matter, my lords, your lordships would recollect that the hearing was concluded, judgment was reserved, my lords. Then the matter came up as...
This one, he wants to make submissions.
My lords. Yes. So my lords had permitted them to file a counter, they filed a counter.
No, what has happened is that, you see, at the time of, while taking up the matter, I found it is totally connected, the immutability and the merits of the matter. So that is why. So then I had to give an opportunity at least to make submissions on the merits of the matter.
They filed the counter, my lords.
I
filed in the morning. You don't want to make any submissions?
No, we want, my lord.
They will have it
tomorrow or next week.
Let it be next week, my lords. Tomorrow will be a
You overloaded also.
Since my friends sitting on.
Little difficulty, my lords, otherwise also.
Next week, any date you propose, and then because we can generate a judgment, that I'll pass judgment very quickly.
Well, it's
But also item 39 and 44, my lord, next week.
44.
39 and 44.
You have taken other side 39.
State government, my lord. Mr. Shulai.
They never object anyway.
Madam, item number 38 also, madam. We are for the petitioner. My other colleague is there, but Mr. Sen is not there, madam, for the state. After a week, madam.
After 2 weeks.
Well,
item 38, 2 weeks, huh?
Yes.
Yes, after 2 weeks, yes. And
my lord, item number 31 also, my lord, if
it's already been adjourned at 31.
31? No, it's not. Respondent, Mr. Paul is there, the senior counsel, and the others are. Next week,
MPSC.
Yes, my lord, MPSC, my lord.
We'll have it next week or when?
Next, my lord, if my lord can accommodate me next week, my lord.
Yes.
Similarly, 36 and 43 also, my lord. 36 and 43. Yeah.
After 1 week, lordship.
Okay, so
Lordship, 35, 36.
37, lordship, are connected, lordship.
Okay.
37 and 43.
43.
After 1 week.
Even for should this prayer for item 41 as well. 41.
Yes, 41.
41 and
connected.
No, it's a different matter. After a week.
Next week, my lord.
Okay. Yes.
42.
Item number 42, your lordship.
That was yesterday, correct?
Tomorrow. No, that was another matter.
A different matter, your lordship.
Different matter.
Oh. Not that one time about movement.
No, that is different. This is different.
What is the matter?
It is regularization.
Nehu?
Yes,
Nehu, yes.
Okay, after 2 weeks.
After 2 weeks.
43? Ready.
Lordship, item 40, Lordship, if you can have
40.
it. Lordship.
40 is only for the 40 is only for the where's Mr. Marpan? The rate you got, how much you want to pay him? Mr. Shulai?
The calculations appears to be correct, my lord.
Yes?
Calculations appear to be correct, but the state has to transfer that amount.
No, that will issue directions. The only thing is that you want to arrive at the correct amount which the petitioners due.
The amount is correct.
Amount is correct.
3 lakh something is covered.
Where's Mr. Marpan? Okay, you have it after 1 week then. But we just inform him. If he says amount correct, then we will.
It's a short order, it can be tomorrow also.
I'll inform you, lordship.
A bit overloaded, yes. Next week, yes. You inform him, Mr. Shulai. We will close it. Yes, because the matter has been heard. Yes.
29. 29.
29, my lord.
Ready.
For report, instruction.
Well, they won't take so long if you have. This one, yes.
Your lordship. Your lordship, on the last date we had sought for time to get some clarifications regarding the amendment. He's not available today, your lordship.
What happened? He's sick?
No, your lordship. Having some personal difficulties, your lordship.
Next week?
Next week, yes. This one will close it also.
Yes,
this
Your Lordship.
matter, the last matter. Hello, Rahman. Yes.
Much
Come,
obliged, Lordship.
where's Mr. Advocate General?
Please, Your Lordship, there's only one order column, Your Lordship.
The remaining?
Lordship, item 27.
Madam.
Apologies, I was not here.
It's only
Madam, sir.
Hey.
Orders. Orders, Shubha.
Name of the party?
Shubha Gupta.
Oh, yes. 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 Well, it's within the confines of review.
Before I start on that, the two matters, Millets. One is, the first one is Pioneer Carbide. This is review petition number 3. And Millets, then there is this other matter filed by BIA. This is review petition number 5. Item 22. Millets, insofar as item 22 is concerned, my instructions are, Millets, we are withdrawing item number 22. Review petition number 5.
To avoid the problem of appeal and
conflict
and appeal and
conflict
review same time.
Even though it is separate, Millets, I can come to that, but
okay,
rather than not going to that, Millets, we are withdrawing item number 5. BIA.
Yes, 22. Raise matter to withdraw the instant review application. Matter is allowed. Matter stands closed on withdrawal. Let's dispose of it. So you only tackling this one?
Only 3. This was the comprehensive writ petition that had been filed, Millets. The BIA matter was in 2 parts. Just to give a factual backdrop, what had happened is originally BIA had come before my lords with the power of the commission to recall its own orders. That was the issue in WPC number 339. Subsequently, my lords, during the currency of that matter, the final tariff order came to be passed. And my lords, there was a comprehensive challenge made by...
Tiwari challenged her.
It was a comprehensive. Both issues, my lords, he had challenged. He had challenged the first issue of my lords, the power of BIA. Power of it had transgressed into 339 Millets.
First he accepted that the commission had the jurisdiction, and then thereafter Eureka moment came to his life.
Some difficulty, Millets, at that point of time. I was in some personal difficulty. So
that is why. So
some confusion, a lot of confusion happened at that stage.
Yes.
Well, it's as I submitted before, my lords, is that there's a limited issue of review here, Millets. In this matter, Millets, there were 2 issues that were core to the writ petition being filed. One was, Millets, that whether the commission has the power to recall its own orders. And Millets, the second issue was with regard to retrospective operation of a certain tariff. These were the 2 issues, Millets. My lords had dealt with the matter in the judgment passed by this Honorable Court. Millets, the 2 relevant paragraphs which I had placed. One was para 35 and one was para 38. 38, my lords, answers the question with regard to the first issue, where my lords have gone into the aspect of the, my lords, the validity of the order passed by the commission itself. And my lords have then taken a view saying that, my lords, the power is available with them, inherent powers are available with them, and therefore, my lords, if that order were to be challenged, my remedy lay under 111 before the appeal. That is the finding of this court. My lords, I'll take my lords to para 38. The only issue that then survives is, my lords, the other issue of retrospective operation of the order impugned. Now, I'll very quickly just take my lords to both these 2 issues. This is the review. I'm sorry. My lords would find my lords' judgment at Annexure 8, page 67. My lords would find...
That can be addressed in the appeal also as a lacuna in a judgment.
My lords, I'm not saying that there is a lacuna. Yeah. What I'm saying is, my lords, there is a gap. That gap needs clarification from my lords.
That's all.
That's all. My lords, at page 113, first I'll just place para 38.
Yes.
Well, as the legality of the impugned order has been deemed necessary by this court to be deliberated and merits of the case discussed is also to discern as to what exceptional circumstances such as the breach of the principles of natural justice or lack of jurisdiction exists, or there is a patent illegality present in the face of the impugned order itself that would render the statutory alternative remedy negatory or futile. But as per the discussions and observations made in this judgment, none exist. As such, the impugned order will surely be amenable to an appeal under 111 of Electricity Act of 2003. That is the question of, my lords, whether the Commission had the power to recall its own orders or not. Now, where we are aggrieved, my lords, and why what has prompted us to come before my lords in this is, my lords, at page 111, para 35.
Yes.
Now, my lords, hold, my lords. As such, as per the discussions and observations made herein above, the fact that the earlier orders dated 5/6/2024 and 6/6/2024 are incompetent and non-honest in law having been established, the exercise of inherent powers of the Commission therefore cannot be said to be without jurisdiction. Matter ends over there. Now, my lords, it has given rise to a peculiar situation. Now, if I'm just given the dates, my lords, may kindly take note of it. My lords, the tariff order for the previous year was passed on 11/4/2024.
Okay. Yeah.
This was never the subject matter of any dispute either between MECL or the industries, my lords. As a matter of fact, they continued to raise bills as per this tariff. We continued to pay. And on that account, my lords, there is no dispute. They also say it is applicable. We also say it is applicable. Now, this particular tariff order, my lords, was Annexure 2 to my writ petition, which was there before my lords. If I may just take your lordships, we have annexed it here as well. My lords would find it at page 17 of the review petition.
Yes.
This is a very voluminous order. We've just taken out the extract of the order. If my lords kindly come to page 21, my lords.
Yes.
My lords, last line, if my lords kindly have a look. This order shall be effective from the 1st of April 2023 and shall remain in force till 31st March 2024 or till the next tariff order of the Commission. This is where the, my lords, difficulty arises. Now, after that, my lords, what had happened? The next order, my lords, my apologies.
This is 11/4/23.
23. My lords, my apologies.
Yes. Yes.
I think, my lords, when it was the dates typed out, they made a mistake. Now, my lords, thereafter, what had happened was that the single member had passed a tariff order on 5/6/2024 and 6/6/2024.
Yes.
This was the subject matter of challenge, my lords, by the utilities, that is MEPDCL, MEPGCL and MEPTCL in 216, 217 and 218 before this Honorable Court. Now, that came to be withdrawn, my lords. Subsequently, there's a spate of litigation. We came, they came. Matter was relegated to the Commission. My lords had allowed both the parties to raise the issues before the Commission. Commission finally passed an order, my lords. On 24, no, I'm sorry. I'll just give that date, my lords. The date on which the thing was passed, the order. Commission. Well, it's the date of the order is very relevant. I'll just give that. No, this is the tariff order. In the month of August, my lords, that order came to be passed. I'll just give it's there in my lord's order.
(23/8).
23/8/2024, my lords. Now, 23/8, my lords, the Commission recalled the orders of 5/6 and 6/6, which was the subject matter of challenge in WPC number 339, as also WPC number 9, my lords. And it passed a final tariff order after following all the issues, my lords, on 24/10/2024. This is the timeline. Now, effectively, my lords, what has happened is the tariff order has come into operation on 24/10/2024.
Yes.
Now, the difficulty with this is, my lords, that in the tariff order, if I may draw your lordship's attention to page 66. my lords would have seen applicability of the order. They say that this order shall come into effect from 1st April 2024. So that is with retrospective operation.
Yeah.
Now, the issue, my lords, is that this was the issue that was already canvassed in this writ petition, in the writ petition WPC number 9, my lords. The review petition is emanating out of WPC number 9 of 25. This issue was categorically canvassed. Now, my lords have not dealt with this issue in that matter. Now, even while holding, my lords, that now why para 35, my lords, I come back to para 35. In the impugned judgment, in the judgment under review, my lords have held that the order of 6.6 and 5.6 were non-est in law. If they were non-est in law, my lords, we get relegated to a position which is of 10.4.2023.
No, 11.4.2023.
I'm sorry, my lords, 11.4.2023. We get relegated to a position, my lords, where there is no order. My lords have held it is non-est.
Yes.
If it is non-est, my lords, that means there is nothing. So we automatically get relegated to a position of?
That means 1 year there's nothing. 11.
Not 1 year, my lords.
Nearly 1 year to 1.4.24.
My lords.
No electricity.
No, it's not a question of no electricity.
No, I mean, there is like, you know.
The issue is.
What do you mean? It's vague, you know. What tariff order will apply? That is your contention, right?
Now, that's why I say, well, there's a vacuum created. Now, the vacuum cannot be filled up by the commission by saying, my lords, that an order would be operational retrospectively. Two reasons for this argument. One, my lords, both are orders passed by the commission. One order, which is not assailed by anybody,
11.4.23,
not touched by anybody, says that this order will be in operation till such time that you pass a fresh order. When the fresh order of 10/2024 comes, my lords, he then says that it is operational with retrospective date. That is from 1/4. Essentially exercising a power of review over an order which is not even the subject matter of challenge anywhere before any court. And it is not only, my lords, not the subject matter of challenge, it has been acted upon by both the parties. Because, my lords, my learned friend would not disagree that from 1/4/2024 till 24/10/2024, MEPDCL continued to raise bills on the tariff as prescribed by 11/4/2023. And, my lords, we continued making payments in terms of the tariff order of 11/4/2023. So this issue, my lords, even though it was urged before this honorable court, my lords, probably, if I can only say, my lords, the larger issue of the jurisdiction of the commission having been assailed before my lords, probably this escaped the attention of my lords. And therefore,
never canvassed that way. That is a gap.
My lords, I will probably, my lords.
Because Mr. Tiwari never.
My lords, the written arguments would suggest otherwise. But this is an issue. I can only bow down.
Yes. See, it would have attracted my attention if this.
It had been placed in this fashion, probably.
It was never placed in this fashion. It was total lateral. Kind of arguments. I'm telling you.
I bow down.
That is why
I bow down. Your lordships will appreciate, my lords. I am at a very sticky wicket. I have the court on one side and a senior friend on another side. And on top of that, I have the Advocate General on top of me.
That is the thing, yes.
So let's. The issue, my lords, is, which is now why I'll have to take my lords to the writ petition, my lords. I'll have to demonstrate before my lords that whether this was an issue before my lords in the writ petition. And if I may, my lords, as I pointed out, we've annexed the writ petition. The court may not have the copy of the writ petition. My lords have the writ petition.
Oh, 9 years.
Well, that's the first thing my lords would sorry. My lords. If my lords kindly have a look at my lords annexure 2.
1 second.
At page 27, my lords.
27.
My lords. This is WPC number 9 of 2025.
Yeah, this is the one. This
is the one that is argued by Mr. Tiwari.
But he never canvassed this point at all.
My lords. I bow down.
How you not stopped now from raising it?
My lords, in the written arguments, my lords, it is there, as well as the pleadings here.
With respect, sometimes written arguments they become too cumbersome.
As I humbly submitted, my lords, I cannot be in a more precarious situation than I am right now in.
Yes, 27.
My lords, at Annexure 2, my lords, at page 27, my lords would have seen this order is annexed, my lords, and page 31 is the relevant portion which I pointed out.
Yeah. Yes.
Now, my lords, insofar as the pleadings are concerned, if my lords, I may draw my lords' attention to page 18.
This is only signed by one person.
My lords, this is another issue, but as I said, my lords, nobody's agitated it before any forum.
This is the 624.
My
Yes.
lords.
No, that has been gone.
That's not agitated, so I cannot agitate it now.
Okay, yes.
Maybe in another proceeding that would be a different issue, my lords. Page 36, my lords. I'm sorry, page 18, paragraph 36, my lords. May kindly have a look, my lords.
Page
18, para 36.
Oh, your pleadings,
my lords. This categorically canvassed, my lords, that the Honourable Commission has failed to appreciate that the tariff order dated 11/4/2023, it is unequivocally clear that it was valid till March 2024 or till new orders of the Commission. The first new order of the Commission was passed on 5/6/2024 and 6/6/24, but the same came under litigation and as such it was not given effect to. However, by the passing of the impugned order dated 24/10/2024, the new tariff order came into existence and as such the new tariff order ought to have been effective from 25/10/2024. But the Commission committed grave jurisdictional error by making the tariff order effective from 1/4/2024. Is further submitted that the tariff orders dated 5/6/24 and 6/6/24 issued by the Honourable Commission for the limited extent of the effective date were legally and valid, being in complete harmony with each other in the judgment of so-and-so, so-and-so, so-and-so. So this is categorically pleaded here, my lords. Because at this stage, I have to, my lords.
So you're asking for the lacuna, but okay, he says that the error only like making it retrospective from 1/4/2024.
My lords, that
now your contention is that what happens to that lost period, after this 11/4/23 to maybe 24/10/24.
Only till that period.
That is
I am only on that.
Not anywhere in the writ petition also.
Well, it's
it just says that government making all effective from 1/4/24.
Well, it says, however, the passing of the
talk about that period from 11/4/23 to 22.
No, my lords. If I may just read it again.
Yes.
Well, it was valid till March or the new orders of the Commission. The first order of the Commission was passed on 5/6/24 and 6/6/24, but the same came under litigation and as such it was not given effect to. However, by the passing of the impugned order dated so-and-so, the new tariff order came into existence and as such the tariff order ought to have been made effective from 25/10/2024.
Right, okay.
That essentially, my lords, establishes what I'm submitting before your lordships, that the period prior to 24/10/24 is the issue with which we are here before your lordships.
No, he only attacks that. He says that you can't make retrospective from 1/4.
It could not be.
That's the only thing. And by making it, and the Commission committed grave justice error by making the tariff order effective from
1/4/24.
So he hardly has quarrel with that. That you pass on 24/10. Why are you making it from 24?
Effective from 1/4.
That's the only thing that paragraph says.
So now, my lords, what I'm saying is that in view of what has fallen,
it a bit to go to to that's the only thing.
Well, it's what I'm submitting before your lordships is, well, it's that in view of what has fallen in from my lords in paragraph 35, where my lords have held that these two orders are non-est. The moment it is non-est, my lords, it is not in operation. Naturally, my lords, we get relegated to the position of 11/4/23. And the moment we are in 11/4/23, my lords, the effective date of coming into effect of the impugned order, well, the order of the Commission, my lords, becomes 24/10/2024. Because prior to that period, my lords, they have raised bills, we have continued to pay bills. That's not disputed by anybody. So that
as per earlier paragraph 11/4/23.
My lords, and we continued paying.
Yes, okay.
And they've accepted it without protest. It's also not a case, my lords, where they have said that it is under protest and in the interregnum this bill is being raised. They don't. They raised regular bills, we paid regular bills. Now, what has essentially given effect to is, my lords, Because of the lack of clarity as to the applicability of which order would be in operation, we are burdened with a liability of almost every company of the petitioner company before your lordships, I'll have to restrict myself to that, is burdened with an additional liability of 2.5 crores for a period for which tariff is already paid. I have no pending bills. It's not a separate issue, Melas, that if I had not paid, then it would have been a different issue. You raised, I paid.
So one thing, Mr. Paul, are you contesting with the 11.4.23 to 1.4.24 part?
I am saying, my lords, that once my lords hold that 6.6 and 5.6 goes,
yes, no,
then we are only in a position where only one order is in existence, that is 11.4.23. And if 11.4.23 is in operation, my lords, and that is not the subject matter of any challenge by, if it is not the subject matter of any challenge by either of the parties,
yes,
then, my lords, there is no question of making a tariff order effective retrospectively, because my lords have dealt with the matter. My lords have said that very well, we have examined the entire merits of the matter. My lords have gone down in depth as to the powers of the commission, my lords, as to whether you have the power of recall or you don't have the power of recall. Now, 2410, my lords, is an offshoot or is a subsequent development to the order of August 2024, by which you recall that order.
Yes.
But my lords have gone a step further, my lords. My lords have said that they were non-est in law.
Right.
The moment my lords say, my lords, that it is non-est in law, then any orders passed by the commission, my lords, is of no relevance anymore. Because the constitutional court then says, my lords, but because of these legal provisions, this did not in the first place exist. I'm sure my lords had very consciously chosen the word non-est.
Yes.
So, my lords, the moment it is non-est, we get relegated to a position which has been acted upon by both the parties, and that issue, my lords, have...
Only one thing, Mr. Paul, we understand your problem exactly. Whether in review we can tackle...
My lords, I am only saying that this was an issue that was canvassed. This, my lords may choose not to decide it. It's not necessary, my lords, as your lordships have said, and I was not in these shoes, my lords, when the matter was being argued.
And never put in this manner.
My lords, I was not in these shoes, so I cannot, my lords, add to what has been submitted before my lords. Probably, my lords, it was not brought to my lords' attention in the manner in which it ought to have been.
Even the petition, it does not say so. It does not reflect that. It only says that whether the commission for passing on 2410 has the power to be retrospective from 1.4. That's all.
My lords, at that stage, one difficulty will be in my defense. I can only say he did not have the benefit of para 35 of my lord's judgment.
Okay.
The moment para 35 comes in, my lords, the dynamics of this entire matter change, which is why I submit, my lords, irrespective of the fact whether the commission recalled that order or did not recall that order. My lords, in exercise of power under Article 226, have come to a definitive finding that those two orders did not exist.
Yes.
The moment that finding comes in, my lords, it's binding on all of us, including the commission, because the commission was a party and participated in the proceedings.
Yes.
So the benefit of 35 was not there, my lords, which is why I say the moment then my lords stop at para 35 by simply holding that non-est. If it is non-est, my lords, then the necessary corollary which
has been put, Mr. Paul, at the point of time, would have addressed it.
I'm sure, my lords.
But in review,
I'm sure. Only issue is, my lords, I am saying that
it's not a fresh petition.
I'm sorry.
It's a fresh petition.
It's not a fresh petition.
They could have easily handled in a jiffy. That's over.
My lords.
But only problem is review jurisdiction.
I have to get past the hurdle of review jurisdiction.
Yeah, that's the only thing.
I'll have to demonstrate before my lords that my lords can actually examine this in review.
Right.
This is why, my lords, I was placing the background of the case. Yeah. Now, the other thing which I had submitted before my lords is, my lords, that it was there in the written arguments. My lords may also kindly have a quick look at the written arguments, my lords, which was filed by all the parties.
I don't have.
In the writ petition.
I don't think it's here.
Read directly back to me.
I don't think it's not before the court. It was only the review and the.
We have made copies. I asked you to make copies of this.
So what happens that all those compilations and arguments are kept, they
once your lordships have dealt with it, my lords, it doesn't.
So from the registry itself, they will.
My lords, what it says here is.
And,
what it says here is, my lords, just for the purposes of saying, there are 3 points. One of them, paragraph 14, they have dealt with it. It says the tariff order dated 11/4/2023 for the financial year 2023-2024 was made effective from 1/4/2023 till 31/3/2024 or till the next tariff order, which I've already placed, Milits. We have a copy? Milits, may I give it? You told me you took 3 copies of this.
This file, Mr. Tiwari.
Milits.
You chose not to retain, so your people have chosen not to retain.
I don't have the copy of it. Give me the copy. After reading also you can give me.
I'll just give it to you. The tariff order dated 6/6 for the financial year so-and-so 14, my lords. My lords have point 14. Well, it says retrospectivity of the tariff order dated 24/10. Well, it's at page 14. Where's MECL's written out? MECL and
Yes.
MECRC's.
Yes.
The tariff order dated 6. It says the tariff order of 11/4/2023 for the financial year 2023 was made effective from 1/4/2023 till 31/3/2024 or till the next tariff order. The tariff order dated 6/6/2024 for the financial year 2024-2025 was made effective from 1/6/2024 till 31/3/2025 or till next tariff order. The impugned tariff order dated 24/10/2024 was made effective retrospectively with effect from 1/4/2024. The tariff order was consequent to the impugned order dated 23/8/2024, by which tariff order dated 6/6/2024 was recalled. Since the impugned tariff order dated 24/10/2024 was preceded by the order dated 23/8/2024 recalling the previous tariff order dated so-and-so, it necessarily follows that the tariff order dated 11/4/2023 for the financial year 2023-2024 remained operational till the issue of the next tariff order, that is the tariff order dated 24/10/2024. Since the tariff order was issued only in October 2024, it could not have been made operational retrospectively from 1/4/2024 because the tariff order dated 11/4/2023 continued to remain operational till it was substituted by the tariff order dated 24/10/2024. Yes, ballots and one judgment is placed.
Just dismiss me. I mean, I'm sorry. I didn't argument. I didn't come to this part. I think
It was not argued also, my lord.
What had happened is, if I may, what had happened is Mr. Tiwari concluded his arguments, Malats, and then I came in, and Malats, he had said, as my learned friend just pointed out, at the first instance, Malats, he had said something. Then, of course, I had to try and Malats take a different view of the matter. The written arguments by the respondents. This is right?
Yes. Yes. What about on the divisional review part?
I would be have to come within the four corners of Order 47. That's my Achilles' heel.
Yes.
Now, it's two authorities that my lords have placed. If I may, my lords, the issue here is that when an issue is urged before my lords, at least in the pleadings, my lords, and if it is not, for whatever reason, my lords, answered by the court, whether that would give me a right to come and review.
Many judgments that says that if it's not argued, it was not bound to answer it.
My lords, absolutely, I bow down. Well, it's by difficulty, as I was not the arguing counsel, I would only have to, my lords, go on the basis of whatever is pleaded and the written arguments which have been filed before my lords. That's why I have brought it.
Personal capacity. He is representing the client, my lord. Whatever client has argued, that is there.
Okay, no, continue. Yes.
No, I have a difficulty, my lords, because there's some other counsel who had argued the matter before my lords. And it was
you bring him back.
And Supreme Court in one of the matter has deprecated the practice of changing the counsel at the stage of review.
No, he's the main counsel. The other counsel was this.
Malits, as I submitted, there was some difficulty at some point, Malits.
Yes.
Of course, something that was unforeseen at that point, Malits, it was unforeseen. Malits, the authorities that my learned friend has placed, Malits, I'm grateful. There are two authorities. The first, Malits, they have placed two judgments, Malits. One is Lily Thomas, as your lordship, sir. My lords, this is 2000 volume 6, page 224.
It is part of the.
In the objection, my lords, they have annexed that judgment. My lords may kindly have it.
In this objection, this is your affidavit. Oh yes. Sorry, I got the wrong one. Yes.
I think they've placed reliance on paragraph 58.
Which paragraph?
Paragraph 58 is, my lords, what they have reproduced.
In this.
But it's page 71.
Objection.
They've annexed the entire judgment, my lords, and the relevant paragraph is at paragraph 13. They've dealt with this. At page 9, paragraph 13.
Page
13, my lords, 1-3.
In 1985.
I'm sorry, my lords. In the objection, my lords.
Yes, it's referring to Lily Thomas judgment.
They have annexed Lily Thomas, my lords.
Now which paragraph are you referring to?
They have referred to paragraph 38, my lords. 58 at page 71, my lords. What find it?
You're referring to that only.
Yes, my lords.
You're addressing that only.
I'll first have to address on that, and then, my lords, try and overcome the hurdle of
paragraph 58.
58.
Yes.
Otherwise, also, if my lords have it, my lords, page 71. Otherwise, also, no ground as envisaged under Order 40 of the Supreme Court rules and Order 47 of the Code of Civil Procedure has been pleaded in the review petition or canvassed before us during the arguments for the purposes of reviewing the judgment in Sarla Mudgal's case. It is not the case of the petitioners that they have discovered anything. It is not the case of the petitioners that they have discovered any new and important matter which, after the exercise of due diligence, was not within their knowledge or could not be brought to the notice of the court at the time of passing of the judgment. All pleas raised before us were in fact addressed for and on behalf of the petitioners before the bench, which, after considering those pleas, passed the judgment in Sarla Mudgal's case. We also are not found any mistake or error apparent on the face of the record requiring review. Error contemplated on the rule must be such which is apparent on the face of the record and not an error which has to be fished out and searched. It must be an error of inadvertence. No such error has been pointed out by the learned counsel appearing for the parties seeking review of the judgment. The only arguments advanced were that the judgment interpreting section so-and-so, this is not relevant for our purposes. Well, I have to try and create a distinction. I have to, my lords, distinguish this finding with the case at hand. Now, the issue here is, my lords, what I've pointed out before my lords at para 37, as well as the written arguments, my lords, this issue was indeed canvassed. This is a separate issue what has fallen for my lords, that probably in the oral arguments, this was never canvassed at the earlier round of litigation. The pleadings, my lords, as they suggest, were that this was an integral issue that, my lords, was there before my lords. And especially in view of, my lords, now para 35, the vacuum that is created by para 35, my lords, would have to be filled in. To that limited extent, my lords, this review application is never for my lords.
Okay.
The second judgment, my lords, which is a judgment passed by this honorable court, my lords. This is in the case of 7 cities.
So next, yeah.
No, they've annexed it.
You have annexed it?
Yes, yes. Page 35 onwards.
Yeah, he's relying on my research, man.
It's called foil and counterfoil. Like it. Fence, sword fence, like, no? Yes.
Well, may I read from page 37 onwards, my lords, paragraph 6. My lords have it. There's a distinction between the maintainability of a petition and whether it makes out any grounds in support thereof. A bare-bodied petition with no allegation in support of the prayer may be maintainable, but the same may fail on merits. Merely because the petition for review may be maintainable, it would not imply that the jurisdiction of review has to be metamorphosized into one of revision or appeal to address the perceived errors or findings under the guise of there being errors apparent on the face of the order under review. qualitatively, a review is quite distinct from an appeal or a revision. Essentially, a review may be maintained when there is some error apparent on the face of the record or the order under review, when some material which was before the adjudicating authority was not taken into account, despite it having significant bearing on the issues involved. This is where I harp. Or when, despite exercise of best diligence, the review petitioner could not produce some material before the adjudicating authority that would have a bearing on the process or outcome of the adjudication, or on some similar reasons that would warrant a relook into the matter. My case is, my lords, restricted to that part where I say that these were issues that were there before, my lords. It is apparent, my lords, that a vacuum is created by para 35.
Would that amount to an error?
My lords, it would not. As I submitted on the first day, my lords, it's not an error. I had submitted, my lords, it creates a vacuum. Now, when a judgment of a court, my lords, creates a vacuum, we have to come before this honorable court for a.
Paul, if it amount to an error, it will be a good ground of appeal that a single judge never addressed this, in spite of it being canvassed, and so this judgment needs to be.
That may be in appeal. That may be in appeal.
It can be remanded back to the.
As I submitted before my lords, that even though this is filed as a review, in essence, my lords, I am only aggrieved by para 35 and not aggrieved by the fact of para 35, my lords. I say that para 35 ends abruptly without addressing an issue which was an issue to be determined by this honorable court in the proceedings.
Yes. Yes.
My lords, if I may also have a quick reading of paragraph 7. On the of the three principal classes or grounds that may be invoked in courts of a review, the most common is the first count of there being an error apparent on the face of the record. The kind of error that can be regarded as an error within the meaning or expression error apparent on the face of the record, face of the order, is a mistake which is obvious and which ordinarily is not required to be brought out with reference to any other material, but the same is self-evident in the sense that it is evident upon plain reading of the order itself. It must also be added that the fourth class of grounds that has been said is ejusdem generis, which are the three classes of grounds that precede it. In short, any or every mistake or any or every error, particularly an error in interpretation or an error in the analysis or perception, may not be an appropriate ground to invoke jurisdiction of review. Well, I am on the first part where I say, when my lords have dealt with the entire sequence of events leading to the passing of these two orders and the power of the commission to recall it, my lords have then provided that these two orders did not exist. The moment my lords then say that these two orders do not exist, then my lords, essentially it creates a vacuum, and the moment there's a vacuum, my lords, then my lords, in my humble submission, would be then my lords required to address that what is the arrangement that would be during that interregnum period.
Yes.
And in essence, my lords, this was an issue that was already here before, my lords. Of course, not in that facet, because by then, my lords, there was this existing issue of whether the power is there or the power is not there. They were only at the stage of a recall order. That, my lords, has now got the seal of this honorable court, where my lords have not only said, my lords, the power of recall is there, my lords have gone on to say that 5, 6 and 6s did not exist. So the moment that comes in, my lords, I fall into that category, that order was already available before this honorable court in Annexure 2. My lords, I have, my lords, not so successfully, if I may humbly submit, pointed out, my lords, that para 37 as well as the written arguments, this was an issue that was placed before lordship, but probably, my lords, not harped adequately enough.
Okay.
So that would enable me, my lords, at least to maintain a review petition before my lords, requiring of this honorable court to at least clarify on para 35, my lords, that once I hold that these orders did not exist in law,
yes,
what is the position that would be then prevalent till the proper order, which again, my lords have said that if you are aggrieved by this order, you go before an appropriate forum. Till that order is passed, what is the arrangement that would be? It cannot be in vacuum. As a matter of fact, my lords, I just borrow from what fell for my lords initially when I was placing the fact that it is almost a case of there being nothing for that one year period.
Yes.
My learned friend was quick to add, there was no electricity for 1 year period. There was electricity, there were bills, there were payments.
We understand, yes.
So it puts us in a very difficult kind of a situation.
We understand your grievance, but we don't know about the relief. That's the only thing.
But if I may, in review, we already come before this court with one leg and one hand tied.
Yes. At least the mouth not. Yeah,
no cap on
vocals, no gag order.
That's the only thing that we have.
Yes. Yes, Mr.
But it's only on this issue, my lords, of what has fallen for my lords. I have just placed these two judgments, my lords. My lords may grant me liberty subject to what my learned friend submits, my lords. On law, if I can just add on.
Yes, my lord. Very short issue, my lord. The review has been sought under Order 47, my lord. Now, my first point is, my lord, that Order 47 says that review is permissible when no appeal has been preferred. Kindly see Order 47, my lord. Order 47 is very clear, my lord.
Masa, that day the court was not keen because
yes, my
when
lord.
you submitted that.
Yes. Your lordship will see order application for review of judgment. Order 47.
1A.
1A. Application for review of judgment. Any person considering himself aggrieved
yes,
by a decree or order from which an appeal is allowed, but from which no appeal has been preferred. Appeal has been preferred before filing the review, my lord. That I have said so in my affidavit, my lord. Kindly see the dates on which it has been said so, my lord. That is paragraph. We have said so, my lord, in clear terms. In paragraph, just give me the paragraph, is, my lord, 20 at page 15. It is submitted the petitioners in the matter have already preferred a writ appeal in the matter. It is submitted that writ appeal 37 up to 2025 was filed on 16th June 2025 whereas review petition number 3 was filed after filing of writ appeal, that is on 17/6 to 2025, and review petition 5 was filed only on 19/6 2025, my lord.
This is filed on?
This is, my lord, filed on 17/6, my lord. Yes.
Appeal was filed on 16.
So, appeal was filed on 16, review was filed on 17.
Yes.
So, appeal not by this
petition.
That list is there, my lords. They have annexed the list.
Now, my lord, now the issue is, my lord, if your lordship will see, who is he, my lord? He is part of Barney Hart Industries Association, my lord. He is one of the association member, my lord. Your lordship has already taken note of that fact in your lordship's judgment and order, my lord. My contention was specifically on that point, my lord, that if your lordship kindly see my argument where I have raised that issue also, and that argument, my lord, precisely at page
of the review application.
Yes, in the your lordship's judgment also only, my lord, that lordship has paragraph, your lordship will paragraph 16 where Mr. Tiwari has submitted the argument, and paragraph just above that, no, paragraph 15. Paragraph 15 at page 83, my lord.
Yes.
No, there is a line.
This one is to Pioneer Carbide.
Yes, my lord. Now this one is lordships have noted that paragraph 12, my lord. Paragraph 12, your lordship has taken note of my argument. Paragraph 12 at page 81.
Yes.
In the instant case, learned senior counsel submits that recall proceedings were initiated on the basis of application of respondent and so were withdrawn on the basis of undertaking a commission. This court that commission will look afresh a matter. As such, he submits the impugned recall order of 23rd August 2024 and subsequent tariff order of 24/10/20 passed cannot be said to be case and action without jurisdiction. It is also submitted that members of Burning Heart Association in gross abuse of process law have also individually preferred several writ petitions challenging the aforesaid order and fixation of. So Pioneer, my lord, Pioneer is part of Burning Heart Industries Association. Now, if the order passed in Burning Heart Industries Association binds the Pioneer also, my lord.
Yes.
He cannot separately challenge the same order before your lordship in individual capacity, my lord. That your lordship has taken note of that. So therefore, to say that I have withdrawn BIA, I have filed appeal through BIA. Assuming, my lord, if the BIA writ appeal
by BIA only.
Yes. Appeal by BIA, and assuming, my lord, if the appeal by BIA is allowed, then whether I can take action against the individual members of the association or not. That judgment will be binding all the members of association, my lord. Therefore, it is nothing but abuse, gross abuse of the process of law when the members individually and collectively file separate writ petitions and separate orders, my lord. It is complete abuse, my lord.
Yes.
So that is the part on first, my lord, bar under 47. Second part is, my lord, abuse. Third part is, my lord, kindly see what was, because whatever is argued before your lordship has meticulously recorded the arguments, my lord, at page 84, my lord.
Paragraph
14, my lord.
40.
14, my lord. Sorry, 16. Paragraph 6, page 84, paragraph 16.
Yes.
Mr. P.K. Tiwari, Learned Senior Counsel assisted by R.J. Das, Learned Senior Counsel petitioner has also placed submission on the question of alternative remedy inherent power of commission brief as they are. Was not made by the commission under any provision or recall in exercise of is not provided. 94 commission has a power of review of decision. Commission has thus no inherent power, so and so. This is the entire argument submitted in the oral argument. If the counsels who argue before your lordship and surreptitiously in the written arguments they put something what was not argued, my lord, it is not a good practice. It is not a good message to the bar. It is not good for the court of record also, my lord, because I will say that look, I have argued this and have not that, my lord, directly just now I found one judgment on this aspect, that what should be your lordship kindly see this similar review was filed in Bombay High Court on similar pleadings.
No, Mr. Paul has also admitted that.
Now, my lord, I have no quarrel with Mr. Paul. I have no quarrel.
Your lordship said that he didn't say, he said it was not placed in the manner it should be placed.
Yes,
he didn't say it was not argument.
I hold Mr. Paul in high esteem, my lord. It is the client. I am commenting on.
He admitted. He said yes.
No, my lord, I should not be mistaken. I hold Mr. Paul in very high regard, my lord. But the only issue is before your lordship, the client is, the petitioner is before your lordship.
Yes.
Mr. Paul, though, I can't contest his case also. Yes. I can't contest the case, my lord. Now, kindly see that because the problem is the issue which is being raised is a larger issue, my lord. This kind of things will keep coming before your lordship, that and your lordship sometimes asks us to give the bullet points, etc., which was argued, and then I take it in review. Look, I have argued this, and the learned single judge has not considered it. That will not, because sometimes in Supreme Court also we have seen that kind of practice, which is if your lordship will kindly come to paragraph 18 straight away, 18 of the judgment. You have this.
Yes.
More disturbing, paragraph 18. More disturbing is the implicit suggestion that counsel's arguments are almost entirely worthless, and by necessary extension the counsels are entirely redundant. If the attorney had filed something on record, counsel must argue it, no matter how trifling or irrelevant. Further, it is the job of the court to engage in some sort of forensic archaeological excavation of these often mountainous records and go through them document by document and page by page to ferret out some sort of case in favor of review petitioner, even if the counsel have never argued even single line of what is pleaded, my lord. Single line has not been pleaded. Whether or not Mr. Krishna agree with my interpretation of his argument as an implication for counsel is totally irrelevant. For that, it is indeed the implication of the submission he makes when he says that my order does not take into account some written submission tucked away at the back of the large file, and also to which my attention was never drawn, and which counsel then appearing made no submission at all. We have counsel for a reason. We expect them certain skills, foremost among them, these is their ability to sanguinely render assistance to the court. The purpose is fundamental. It is not achieved by saying that counsel's arguments are irrelevant. It is not achieved by the saying that counsel overlooked or what they are not properly briefed, or that counsel ought to have but did not take some point. Counsel often realize, as well as they should, that not all arguments taken in affidavits, even in written submissions, are worth pursuing. They confine their arguments to a few points, and they know that rest do not matter and will not convince. If the counsel has not argued a point, the fact that there were written submissions is immaterial if those written submissions were never in fact argued. Counsel's failure to argue written submission is not a ground of review, or I dare say even appeal. It is no ground to assail any order of any judge of any court if the written submissions were to be relied on, and that ought not to have been done during the argument, or at any rate while judgment was being dictated in the open court, or at best shortly after judgment or order was uploaded. These never argued written submission cannot be taken in hindsight. Sometimes after argument closed we permit written submissions. That requires an order of the court, and the court then always reference to written submission is called for. There is no such order calling for written submission. Not in that case, there was no. But the fact of the matter is, what was said in the written submission was admittedly never argued, and that is not a ground for review. Now, my lord, the issue is what is being sought to be reviewed before your lordship. Kindly see what was the issue your lordship has framed in the matter. Your lordship has held that the orders of the MSCRC are amenable to appellate jurisdiction. That is the conclusion your lordship has reached after meticulously examining the provisions of law, judgment and case law. The order of MSCRC is that the tariff order will come into effect from financial year of 1st April 2024, my lord. That is because this tariff order was from 1st April 2024, my lord. The previous financial tariff order is from last financial year, my lord. So if they are aggrieved,
that's amenable to appeal. Yes.
Amenable to appeal before the before the division. So therefore, there is what is the error in my humble submission? There is no error apparent on the face of record. There is nothing. So therefore, if your lordship will kindly see your lordship's judgment, my lord, which has meticulously examined every issue, the issue your lordship has framed. Your lordship's judgment starts from page 71. And then your lordship records the submissions of parties. After recording the submissions of the party, your lordship at page 90, my lord.
Yes.
Frames the issue, my lord. The court, having heard, paragraph 23, having heard the respective counsel in these writ petitions, notes that issue in question is with regard to the jurisdiction of the commission to recall its own order and exercise of the inherent power, and whether writ petition on the availability of alternate statutory remedy will be maintainable in application under 226 of the Constitution. As noted earlier, counsel for the petitioner have contended that a statutory appeal remedy available would not serve to address the grievance of petitioner as much as the impugned order of recall dated 23rd August and subsequent tariff order dated 24/10/2024 are wholly without jurisdiction and patently illegal on the record. Court therefore would examine, my lord, as to whether the statutory alternate remedy provided under section 111 of the Electricity Act would be efficacious as contended by petitioner. So sole issue is whether your lordship has examined whether the orders passed are wholly without jurisdiction and amenable to your lordship's jurisdiction under Article 26 or not, 226 not. Now, my lord, your lordships have already taken note of all these provisions, and the finding, my lord, 35 again and again, which has been repeated, my lord. Your lordship will see the Your Lordship has taken note of each and every argument, and 34 Sri infrastructure in paragraph 34, and finally, my Lord, 35, my Lord.
Yes. Yes.
As such, as per discussions and observations made herein above, the fact that earlier order are incompetent non-est is in law having established the exercise of inherent power cannot be said to be without jurisdiction. Now 36 caveat your Lordship adds. The submission of learned counsel for the petitioner in writ number 9 and so an Electricity Act is only is subject to only underline the principle that one who decide must hear and cannot be expected to mean those who hear must collectively decide. And after saying so, my lord, at the penultimate paragraph, paragraph 38, your lordship has said these observations are only for the purposes of deciding whether your lordship is entertaining the the 38. The legality of impugn order has been deemed necessary by this court to be deliberated, and merits of the case discussed is also discerned as to whether exceptional circumstances such as breach of the principle of natural justice or lack of jurisdiction exist, or there is a patent illegality in the face of the impugn order itself that would render the statutory alternate remedy negatory or futile. But as per discussion and observation made in this judgment, none exist, my lord. So your lordship has said that this is only for the limited purpose for examining as to whether these three-part tests are met in this case or not. So therefore, whatever observations have come from your lordship, it is only for the limited purpose of saying that whether the remedy is available to the writ petitioner or not, my lord. Again, if he is aggrieved by the order of this honorable court, by the order of the MSCRC, that this order cannot come into effect from 1st April, that remedy is always available to him under section 111 of the Electricity Act. My lord, now I have summarized my argument. One recent judgment of the Honorable Supreme Court, in fact, on that judgment, my lord, after pendency of the appeal, filing of the appeal, there is one judgment of the Honorable Supreme Court. Says that in one of the passing paragraph, my lord, Tungbhadra, my lord, that judgment is there where interpreting order 47, my lord. And if your lordship will kindly see paragraph 7, Tungbhadra judgment, paragraph 7, your lordship. Paragraph 7 at my lord, at the foot of the page of paragraph 7, last paragraph.
Order 47.
Order 47, rule 1 of the Civil Procedure Code permits an application for review being filed from a decree or order from which an appeal is allowed but from which no appeal has been preferred. In the present case, it would be seen on the date when the application for review was filed, the appellant had not filed an appeal to this court, and therefore the terms of so-and-so did not stand in the way. Here, appellant has filed the appeal through his association, my lord, Burney Heart Association, BIA. That is very much clear, my lord. Even the affidavit filed by in the BIA appeal is by the same person who has filed review, my lord. Yes.
We don't have the appeal with us anyway.
Yes, PK.
That's a side argument.
Yes, your lordship, PK. If your lordship will see that, I do not. But the issue is that he is the same person who has
in the appeal also
filed the affidavit also, my lord. That there, my lord. Now kindly come to my counter affidavit, my lord, which I have dealt with that. The Maithan. So that is. Second party, you are in this petition.
Maithan is not preparatory. Maithan is not preparatory. It's only binding.
And but the affidavit is by same person. Your lordship, kindly see my submissions, my lord. That your lordship will because I have quoted the relevant part of your lordship's judgment, etc. Now paragraph 11, where your lordship kindly come to my counter affidavit, paragraph 11 at page 6, my lord.
Yes.
Your lordship will judgment. The review petitioner has instituted the instant review petition seeking clarification for the ambiguity and uncertainty as mentioned in ground 1 of review petition. Further, ground 2 appears to be preferred to seek further decision on the question as to whether a single member can pass a judgment. If yes, then what circumstance? It is submitted such determinations are far beyond the realm of review and they amount to fresh attack on the merits of the case, which cannot be permitted in review jurisdiction. The relevant part of the grounds are taken, my lord. I have called out the relevant part, my lord. Paragraph 12, my lord. It is submitted that a review is maintainable only in terms of grounds provided in section 114, read with 47. It is submitted none of the grounds have been made out in the present case. It is submitted evidently petitioner has not placed reliance on new material. Petitioner's contention is that there is a perceived ambiguity and uncertainty emanating from the order of 2.6 which as per review petitioner is palpable error on the face of record. It is most humbly submitted that review jurisdiction is not available for clarification of the perceived and alleged ambiguity and uncertainty emanating out of the order. Review jurisdiction is amenable only if there is a patent error on the face of record. However, petitioner has failed to demonstrate any patent error on the face of record. The learned division bench of the Honorable High Court in 7 City, by judgment dated so and so, had on occasion to elucidate the contours of the review. The relevant part of the judgment in 7 City is, my lord, and a bold part, my lord, a bare-bodied petition with no allegation in support of the prayer may be maintainable, but but the same may fail on merits. Merely because the petition for review may be maintainable, it would not imply that jurisdiction of review has to be metamorphosed into one revision or appeal to address the perceived error of finding under the guise of there being errors apparent on the face of the order under the review. Qualitatively, a review is quite distinct from an appeal or revision. Essentially, a review may be maintained when there is some error apparent on the face of record or order under review, and when some material which was before the adjudicating authority was not taken into account despite it having similarly bearing on the issue involved, and when despite exercise of best diligence the review petitioner could not produce some material before the adjudicating authority that would have had the bearing on the process or outcome of the adjudication or some or similar reasons and would warrant a relook into the matter, my lord. If I apply the ratio of this judgment, my lord, here the gap or no gap, my lord, will have no bearing on your lordship's finding that there is an alternative remedy under section 111 of the Electricity Act, my lord. That will have no connection with the review. On next page, my lord, the kind of error that can be regarded as an error within the meaning of expression, error apparent on the face of order, is a mistake which is obvious and which ordinarily is not required to be brought out with reference to any other material, but the same is self-evident in sense that it is evident upon a plain reading of the order itself, my lord. And then, my lord, Lily Thomas paragraph, relevant paragraph, my lord, I have culled out in for the sake of convenience in next paragraph, paragraph 13, my lord.
Yes,
and that is, my lord, bold part, my lord. I am placing reliance on the bold part of my error contemplated under the rule must be such which is apparent on the face of record and not an error which has to be fished out, and such it must be an error. It must be an error of inadvertence. It meant, my lord, next bold part, it is essential that it should be something more than mere error. It must be one which must be manifest on the face of record. That error, no error could be said to be apparent on the face of record if it was not and self-evident, it was not established, my lord. I have placed that judgment, my lord. And then, my lord, the order of 24/10/2024 clearly says that the order will come into effect from 1st April 2024. The commission, our case, that commission had jurisdiction to pass that order. Commission has exercised the jurisdiction to pass that order, and that to that extent your lordship has held that commission prima facie has the power to pass that order, my lord. Your lordships have held. And then one judgment at page 14, my lord, is Parisoni Devi versus Sumitri Devi. Paragraph 7. It is well settled that review proceedings have to be confined. Paragraph page 14. Confined to ambit a scope of. So here, my lord, they are placing the written submission. Those are also not part of. It is settled that review petitions have to be strictly confined to ambit and scope of order 47. Tungbhadra, my lord, we have already placed that Tungbhadra before your lordship. However, we are not now concerned with is whether the statement and order that the case did not involve any or any error, the fact that, my lord, this judgment is squarely applicable. And then paragraph 9. This is very clear, my lord. Now, paragraph 20, my lord, kindly see what has appeals and details of appeals which have been preferred by parties. It is submitted the present review petition is abuse of process of law barred by. It is submitted the petitioners is the matter already preferred a writ appeal in matter. Was filed on 6/6. I have already given the and tabulated list of appeals are also, my lord, mentioned here. The dates are also mentioned.
Oh, you filed a series of appeals.
Yes, my lord.
Okay.
These are the appeals and they are coming up for hearing tomorrow, my lord. And then your lordship at the foot of the page 17, my lord, grounds also, your lordship, kindly see the grounds which they have taken in appeal and review petition in here, my lord. If writ appeal, my lord, ground is 37 of 2025. For that, learned single judge has failed to appreciate that only the power of review is available to the respondent number 1 under regulation 31, which require a formal petition can be entertained only if the settled parameters of review jurisdictions are met, failing which the only recourse available is to challenge the tariff order before the appellate tribunal by the aggrieved party, even if only on the ground of lack of quorum, the recall tariff procedures it goes and exercise so and so. And then, my lord, in review petition, my lord, what they say, paragraph 18. Sorry, page 18, middle. However, the law relating to whether single member can pass an order in what circumstances has not been let down in observation, and so passed the single member in the has been interfered with invalid and non-honest, my lord. And after showing the for that taking holistic view of the matter, so these are the grounds which they have taken before the in appeal. The if your lordship on next page, if your lordship will see in appeal. First column is appeal. The learned single judge failed to appreciate it is a settled principle of law. The once quasi-judicial concludes the adjudicatory, it becomes functus officio in respect of subject matter. Respondent having signed and issued the first tariff order had no occasion to reopen the withdrawal. And here what is being played, my lord, that this order is non-honest and therefore your lordship review the order. In the appeal, what they say that the commission is functus officio, and here they say, so my lord, if your lordship has seen the grounds, etc., and paragraph page 17, paragraph 22, my friend is instructing me to read, my lord, paragraph 22 of this. That's a submission, my lord. 22 of 22 of this petition, my lord. Page 16, reply, my lord. It is submitted review petitioner in review petition has itself admitted having filed an appeal for the sole reason for preferring the instant review is that writ appeal has not been taken up for consideration. Yes, 22. It is submitted that it is considered that the case is also subject matter of appeal only because the appeal is still to be heard and review petition has been prepared. In most humble submitted, review can be prepared only on limited ground available under 47. Merely because appeal has not been taken up, hearing cannot be ground. It may be noted that writ appeal has been listed for consideration so and so. Moreover, the review petitioner has taken inconsistent plea where on the one hand, the review petitioner has challenged the judgment on the issue regarding power of MSCRT to recall its order of 5/6 and 6/6, and on the other hand, in review petitioner, it has been contended law has been settled by the impugned judgment. Now further clarification required, my lord. Both can't swim together, my lord. Either the stand that this is the finality and clarification is required, or your lordship's order is subject to appeal before the division bench. Both can't swim together, my lord. And therefore there are three judgments, my lord. There is one recent judgment of Justice Dipankar Datta on the issue of review also, my lord, that Justice Datta has again examined in 2024. You have another copy? Yes, lordship may have. Yes. Paragraph 8, my lord. And this is good judgment on contempt jurisdiction also, my lord. I was going through for the purpose of contempt, but contempt also, but because we get a lot of contempt matters, so I was reading in that the Justice Dipankar Datta has dealt both contempt jurisdiction also, but that is not relevant here, my lord. Paragraph 8. The present list confronts us primarily with two interrelated legal issues. First one requires us to examine whether parameters set out in order 47 rule 1 of CPC for exercise of power of review as in para 8, I'm sorry, my lord, analysis.
Yes.
The present list confront us primarily with two interrelated legal issues. First one requires us to examine whether the parameters set out in order 47 rule 1 of CPC for exercising the power of review as interpreted this court in numerous judgments were at all satisfied by the High Court to embark on the exercise review. The second issue relating to consideration termination light of provision 20 of read with. So that the second issue, my lord. Now, my lord, kindly see paragraph 11. while proceeding to determine the correctness of the impugned order vis-a-vis exercise of review jurisdiction, we ought to remind ourselves of certain cardinal principles. The exercise of review jurisdiction is not an inherent power given to the court. Power to review has to be specifically conferred by law. In civil proceedings, review jurisdiction is governed by section 114 read with conjunction of 47 of CPC, and the court has to be certain that the elements prescribed therein are satisfied before exercising such power. Court in Kamlesh Verma Mayawati has succinctly observed, review proceedings are not by way of an appeal and have to be strictly confined to the scope and ambit of Order 47 Rule 1 of CPC. That the provision contained in section 114 and Order 47 of CPC relating to review and order decree are mandatory in nature, and any petition for review not satisfied the rigors therein cannot be entertained ex debitio justi by a court of law is tried. There is a plethora of decisions analyzing the statutory provisions governing the exercise of review. However, we would be referring to a few of them for the purpose of present exercise. Suffice it to note that despite legal proceedings having commenced with the institution civil suit 9, the present controversy has source of writ petition between the first respondent and Tahsildar 2009. Though CPC would not apply to the proceeding under Article 2026, there is an authority in abundance that the principles flowing from CPC may safely be taken as a guide to decide writ petitions, but to extend the same can be made applicable. To put it plainly, Order 47 Rule 1 of CPC provides 3 grounds for review. Discovery of new and important matter of evidence which after the exercise of due diligence was not within the applicant's knowledge and could not be produced by the applicant at the time when the decree was passed or order made. 2. Mistake or error apparent on the face of record. Or 3. For any other sufficient which must be analogous to either of the aforesaid ground. In Mohanlal Basilius Catholics versus Most Reverend Mar Paulus Athanus, this court approved the view that the third ground, any other sufficient cause, must mean a reason sufficient on grounds at least analogous to first 2 grounds. Same view has been reiterated in recent decision in State of NCT versus KL Rathi Steels. The court affirmed that the scope of third ground has to be narrowly construed so as to not traverse beyond the orbit of the first 2 grounds. Since the division bench invoked the first clause, we hasten to emphasize that applicant seeking review on the basis of discovery of new has to be demonstrate first that there has been discovery of new evidence of which he had no prior knowledge, or that it could not produce at the time of decree was passed or the order made despite due diligence, and secondly the new evidence is material to the order decree being reviewed, in sense that if the evidence were produced in court when the decree was passed or order made, the decision of the court would have been otherwise. Ultimately, it is for the court to decide whether review ought to sought by an applicant, if granted, would prevent abuse of process of law. Lordship, last 2 line, my lord, is important. The order made or decision would have been otherwise. This discovery, my lord, of that nullity, ambiguity will not have any effect on your lordship's finding that there is an remedy of appeal under section 11, my lord. 17. When the ground for review sought is that of discovery of new evidence, the court in the state of West Bengal versus Kamal Sen Gupta has clarified that same must be evidence which would be materially important to decision taken. The following passage is instructive. At this stage, it is apposite to observe that where a review is sought on the ground of discovery of new matter of evidence, such matter or evidence must be relevant and must be of such character that if the same had been produced, it might have altered the judgment. In other words, mere discovery of new or important matter or evidence is not sufficient ground for review ex debitio justice. Not only this, party seeking review has also to show that such additional matter or evidence was not within its knowledge, and even after exercise of due diligence, same could not be produced before the court earlier. In the light of the legal principle crystallized of the above, we proceed to discern rational in this one. So, and my lord, it was held that review was not maintainable. So the principle, my lord, in Tungbhadra, in this Trupati Rai, Lily Thomas, and even the judgment of this honorable court, my lord, leave no scope of doubt, my lord, that there is no case whatsoever for no case is made out for review whatsoever, my lord, because there is no error apparent on the face. In fact, there is no error, my lord. There is no error. The order was challenged. There is even, and in written submission, they say that this should have applied from the April. Not that is also no ground for challenging the order of MSCRC. That remedy they have in the electorate appellate tribunal or before division bench, my lord. So this is all I have to submit on my.
We'll pass orders then.
It's two issues I'll need clarification.
I think
two issues, my lords.
because yes,
on facts, my lords.
on facts.
No, because they have said, my lords, what my learned friend has probably missed out is, my lords, which is why I had at the first instance before embarking on my arguments on this matter, my lords, I decided we chose to withdraw review number 5. That has a bearing, my lords. As your lordships would have seen in para 20 of their objection, they have called out, my lords, who are the who are the appellants before the division bench.
But are you part of BIA or not?
My lords, that is dealt with in para 15 of my lord's judgment. I'll take
Part of BIA.
No, I may be part of BIA, but my lords. No, I did not disturb my learned friend when he was. But my lords have dealt with that aspect at para 15, which is why para 15 becomes very relevant. Where's the review?
BIA memorandum of association and their name is there, my lord.
Oh, that's okay. I'm not disputing it.
So now
I'm not disputing.
Maybe undisputed.
I'm not disputing it.
They are part of BIA, my lord.
If my lords may kindly deal with para 15 first. Well, it's before proceeding further, at this juncture, in the considered view of this court, it would be expedient to examine whether two subsequent writ petitions, which are tagged together with this writ petition 339, is by BIA, my lords. WPC 9, Messrs. Pioneer Carbide, and WPC number 13, Sham Century, which are common and similar to WPC 329, wherein submissions of the respective parties have been recorded. In WPC 9, the same order so-and-so, that is order of 23.8, has been assailed, and in WPC number so-and-so, the resultant tariff order of 24.10, 2024 has been assailed. So, my lords, even at that stage, took cognizance of the fact, my lords, that my lords were dealing with 3 different writ petitions. One by BIA, and my lords, one by Pioneer, and one by Mython Alloys. So, the question is, my lords, that this judgment is a common judgment that my lords have passed in 3 writ petitions, 339, 9, and 10.
Yes.
So, merely because, my lords, BIA has gone up in appeal in 339, and as your lordships have recorded in para 15, 339 only challenged, my lords, the order of 23.8. The comprehensive challenge was in the subsequent 2 writ petitions, and which is why my lords deal with those matters separately. That's number 1. Now, number 2, my lords, in the objection that my learned friend was reading before my lords, as it is, my lords, I have if not an uphill, I have an impossible task of climbing in a review. I don't want to be let down on this issue of appeal being filed. My lords, page 17, what was being read before my lords at page 22, the tabulated chart that they've prepared.
In
the objections, my lords.
Yes.
Writ appeal number 37, my lords, would see the first is what they say are the averments in the appeal of BIA.
Page 22.
Page 17, my lords, 17.
Yes.
My lords have it.
Yes.
Writ appeal number 37 is BIA.
Yes.
Review 5 was BIA.
Yes.
Which is not there for consideration anymore, my lords, because my lords have permitted withdrawal of that. Which only leaves us with review petition number 3 of 2025.
Yes.
And my lords, there is no similarity insofar as what is there in 37 and what is there in 3 before, my lords. That is what was read out. As a matter of fact, if my lords, I don't want to burden my lords after having read out, it is highlighted, my lords. At page 18, my lords would have seen. Surprisingly, the tariff order dated so-and-so and a financial so-and-so not being challenged nor being honest, the party stands relegated to the said position as on so-and-so, which subjects the parties to ambiguity and uncertainty. The said error being palpable and apparent on the face of the record, the judgment on so-and-so dated is therefore liable to be reviewed. Then, my lords, at 2, at 19, however, again highlighted, I'm just reading, my lords, what's there in the review. However, the law relating to whether the single member can pass an order in circumstances has not been laid out, observed in the judgment on order, though the orders passed by the single member in the matter has been interfered with as invalid and non-honest. Para 35, what I pointed out, my lords. As such, the order of so-and-so is liable to be reviewed. That has no bearing with what is the case of BIA before the division bench, whereas BIA's challenge is only with that power to recall, my lords. Now, the other writ petitions, if my lords would recall, that on even date, my lords, there were 2 judgments delivered by my lords. On the same date.
Separate judgments.
My lords. That's covered by a separate judgment. That all those 5 appeals, my lords, of which...
It is part of the counter.
My lords, this WA number 38, 39, 40, 41, 42.
Next year.
No, they've not. They've mentioned it, my lords, at page 15.
Oh, I understand. Yes.
Yes, your lordship has said in the light of the order passed.
It's a separate judgment in all those 5 matters. So obviously, my lords, that cannot come in the way of this. There's a separate judgment by which my lords have dealt with those 5 matters, and by a common judgment, my lords have dealt with 3 matters, that is BIA, Pioneer, and Mython.
First annexure, my lord.
Sham Century.
That is first annexure.
Pure annexed.
Yes. That is page 27, my lord.
Yes.
Yes.
And page 33, your lordship.
Yeah, it's of even date.
Page 33, my lord.
So that obviously will not have any bearing insofar as this is concerned, my lords. Only issue is that in the judgment passed by this honorable court, my lords, in the BIA matter, whether, my lords, an appeal being preferred by BIA would preclude, my lords, Pioneer, who was a separate petitioner maintaining an independent writ petition before my lords, which have been dealt with by my lords, would then, my lords, the rigors of, my lords, 41(1)(c) would then come into 1A would then come into play. That, in my humble submission, was not there. Insofar as the law is concerned, my lords, my learned friend has placed a series of judgments, my lords. I was only praying if my lords grant me a day's time, I'll just rebut on these issues.
You give citations only.
Citations, authorities.
47, your lordship may kindly just take note of this Dipankar Datta judgment, my lord. That is judgment in Trupati Rao versus Lingamalaya, my lord. That judgment, paragraph 5 missed out, my lord. 47 on interim orders, because they have obtained certain benefits from the interim order, my lord. 47. Yes, my lord. The 2014, 2024 SCC online SC 1764, paragraph 47, my lord. And one short point, my lord.
Let him supply the other judgment.
Yes, my lord.
47.
My friend is saying there's another short point, my lords. I'll have to reply on that also.
No point. Point is over. No point. No, tomorrow again he will go and take
into like
yes.
Into
my lord, only thing is
it's just that examine on the aspect 47 only.
Yes.
So we'll have to go on this issue of 47, my lord. As I said, that
is what
it's not even a sticky wicket, well, it's a wet wicket.
But
the match will get washed out.
Mr. Paul is not here. His erudite argument is his erudite only issue is the petitioner.
No, he's doing a fantastic job of repairing, you know. It's like repairing a building that's collapsed. It's like that. Yes. Tomorrow you surprise authorize tomorrow.
Yes. Grateful, my lord.
Yes, sir. Matters heard, matters hearings concluded. Mr. K. Paul to supply citations.
Authorities.
Or you want to make submissions now?
But I'm not available, otherwise also I'll not take time. We'll just only, my lords, because what has been stated, if I can elaborate on that little exception that Lily Thomas provides.
I'll obliged.